All right, thank you so much. I think we are ready.
Perfect. Would like to welcome everyone back to the afternoon open session for the Board of Psychology. And Ms. Pruteau, can you please call the roll?
Yes.
Thank you.
Kasuga?
Here.
Cervantes?
Here.
Fu?
Hi.
Harb Sheets?
Here.
Nystrom?
Here.
Phillips?
I'm here. I think we have our attendees are still locked out.
Hi, Dr. Phillips. This is Jason. Is there somebody specific?
It looks like everybody on the attendees list has still got a locked logo by them.
Right.
Oh,
Attendees are locked.
Oh, I see. Okay,
yeah.
never mind.
This is the moderator. The attendees can't mute and unmute themselves, so that's why the little lock symbols next to their microphone.
I got it. I was just concerned they were still shut out. Thank you.
Okay. Riscate?
Here.
Rogers?
Here.
Tate?
Here.
Thank you. Roll's complete.
Perfect. And everyone is here and accounted for. We're going to take up agenda item number 7, which is a petition hearing. And I'm just double checking. I see Deputy Attorney General Yates, Judge Liu. I'm looking for the petitioner. Mr. Glass-Steagall, do you see the petitioner?
We don't at this time. We are still looking, though.
I'm looking too.
This is the moderator. I have a call-in user that might be our petitioner. So I'm going to request to unmute their microphone to confirm if that is our petitioner.
Okay, thank you.
Hi, this is Manmeet Ratu. I am the petitioner.
Okay, let me go ahead and promote you. And then I also see that your legal counsel is on as well. So I will promote him as well. And then since you're audio only, you'll want to press *6 to unmute yourself, and then *6 again to mute yourself.
Is everyone, we ready to go? Great. Judge Liu, you have the floor.
Well, good afternoon. And let's not quite yet go on the record. I want to confirm a few things. Let's see, our court reporter is here. Mr. Kravitz, you're here, and Dr. Ratu.
Yes, I am.
Okay, we're doing this entire hearing by audio. And
Okay.
I don't know if you have arrangements to speak directly with your client or if you're physically together in the room, but I'll let you work that out. During the course of this hearing, if there are any issues, we have a very good moderator who can assist all of us in that respect. The Deputy Attorney General in this case is Mr. Lent. And I had an email earlier about a document that may have been filed today. Is that the case?
Yes, there was an updated resume for the petitioner.
Okay, and I'm just speaking generally to the board members, staff. Is that a document that has been provided to board members?
I have a copy of it. It was sent to my inbox today. This is Zeron Fu.
Okay, if it's an updated resume, it's probably not as consequential perhaps as other documents, and I'm to be corrected, please do so, but let's make sure that it comes into the possession of everybody. Other than that document, everything else is pretty much on file with the board, correct?
Yes, that's correct.
All right, Mr. Reporter, let's go on the record, please. And this afternoon, we're reviewing a petition for early termination of probation. This is being heard before the Board of Psychology. All 9 board members are present. The petitioner is Dr. Manmeet Ratu. Dr. Ratu is represented by Mr. Jeffrey Kravitz. This has the agency's case number 600-2020-001001, as well Office of Administrative Hearings case number 2021-120336. My name is Jonathan Liu. I'm the assigned administrative law judge to assist this board today. The Department of Justice is represented by Mr. Aaron Lent, Deputy Attorney General.
I'm sorry, Your Honor, this is Ryan Yates. I'm actually going to be handling this.
Thank you. Forgive me for not catching that. Ryan Yates.
Yates, Y-A-T-E-S.
Thank you. So in these proceedings, I'm going to ask Mr. Yates to lead off by providing the board background on this case. Board members by now have received a copy of the petition and all supporting documents. Following Mr. Yates' review, I'm going to invite Mr. Kravitz to present the petition. Matters for hearing today. Mr. Kravitz, in my experience with this board, probably in your experience as well, board members have by now read and are familiar with the history of this case. I tell everyone who appears before boards to focus on those matters they wish to highlight, and as importantly, those matters that have occurred subsequent to the filing of the petition. Following your presentation of the petition evidence, I'm going to invite Mr. Yates to examine Dr. Ratu. Following that examination, I'm going to invite all board members, generally in alphabetical order, to ask any questions that they may have. And at the conclusion, I'll invite each of you, Mr. Yates and Mr. Kravitz, to make a closing statement. As indicated, this is a little bit different than council are used to, but it's worked at least once today. It's my first time doing hearing without seeing anybody. It actually works quite well, although not ideal. So with that, let's proceed. Mr. Yates, would you lead off, please?
Thank you, Your Honor. And before starting, my first time doing radio as well. Can you hear me okay?
I can hear you fine.
Great, thank you. So my name is Ryan Yates, Deputy Attorney General. I'm here to ensure the board has adequate information from which to make a decision. My role is not adversarial in nature, but I'm here to assist with fact-finding. Respondent has waived her right to a live hearing, and as such, we are here telephonically. So moving ahead, I'd like to start with summarizing the background. On September 12th, 2001, petitioner Manmeet Ratu was convicted in Alameda County of driving under the influence of alcohol, a misdemeanor. Petitioner was placed on probation for 3 years. On July 16th, 2008, petitioner was again convicted by the Alameda Superior Court after pleading no contest to driving under the influence of alcohol with a blood alcohol content of 0.08% or higher, a misdemeanor. The sentence was suspended and petitioner was placed on probation for 3 years, required to attend a drunk driving program, and spent 10 days in custody, which was through an alternate work program. And moving ahead, on July 22nd, 2010, petitioner was convicted in the Superior Court of San Francisco pursuant to a plea of no contest to alcohol-related reckless driving, or more commonly known as a wet and reckless, also a misdemeanor. Respondent was sentenced to 1 year in county jail. Execution of the sentence was suspended, and respondent was placed on probation for a period of 3 years on terms and conditions, which included 10 days in jail, attend a second drunk drivers program, pay an assessment and fines, and no driving without an ignition interlock device. On January 17th, 2013, petitioner was convicted in Contra Costa Superior Court pursuant to a plea of no contest for driving under the influence of alcohol with a blood alcohol content of 0.08% or higher, a misdemeanor. Imposition of the sentence was suspended and petitioner was placed on probation for a period of 5 years, 180 days home detention, another drinking and driving program, and driving privileges revoked for 5 years. In 2018, following successful petitions by petitioner, the aforementioned Superior Courts granted petitions to dismiss each of the aforementioned convictions. On January 26, 2017, the board received an application for registration as a psychological assistant from petitioner. On the application, petitioner was asked whether she had been convicted of any criminal or civil offenses, including citations, infractions, or traffic violations over $500, misdemeanors, and felonies. Although respondent submitted information regarding most of her convictions, respondent failed to include information regarding her 2010 conviction. On October 3rd, 2017, the board denied petitioner's application for registration as a registered psych assistant. And on January 23rd, 2018, a statement of issues was executed by the board, which outlined the aforementioned facts and requested the denial of petitioner's registration as a psych assistant. The statement of issues provided the following as causes of action: convictions of substantially related crimes, commission of any act warranting suspension or revocation of registration, and any false statements of fact. You can find these statements in the complainant's Exhibit 2, but that's just summarizing it. Following the hearing, the Office of Administrative Hearings on October 18th, 2018, an OAH decision became effective, which affirmed a previous proposed decision by an ALJ. In the proposed decision, the administrative law judge found petitioner to be rehabilitated and granted petitioner's application for registration as a psychological assistant and placed her on 5 years probation with terms and conditions which included a practice monitor, clinical diagnostic evaluation, alcohol and drug treatment program, ongoing support group program, abstaining from drugs and alcohol and submitting to tests and samples, employer notification, coursework, ethics course, and standard terms and conditions. That aforementioned order is included in complainant's Exhibit 3. So on October 18th, 2018, petitioner was granted a license as a psychologist. However, based on the previously stated facts, the license was probationary under the same terms and conditions as previously mentioned, and probation told for 2 months, and petitioner began her probationary term in December of 2018. So as of today, petitioner is set to complete her probation in December of 2023. On May 28th, 2019, while petitioner was on probation, she received a citation order or order of abatement from the board for failing to follow the terms and conditions of her probation. Specifically, petitioner was charged with failing to undergo random biological fluid testing by failing to provide a fluid sample. She also failed condition 11, as she failed to submit quarterly declarations under penalty of perjury regarding those compliance statements. Additionally, she violated term 12, probation compliance. She was further charged $250. On September 30th, 2019, petitioner received a citation order of abatement from the board for failing to follow the terms and conditions of her probation. Specifically, petitioner was charged with failing to pay her probation costs and for violating term 12, probation compliance. Again, she was charged $250. Regarding petitioner's relevant employment background, it's as follows. Between 2016 and 2017, petitioner worked as a psychology postdoc resident at a medical center in Northern California. Beginning in 2018 through this day of hearing, petitioner has worked as a clinical research psychologist at a medical university in Northern California. Beginning in 2019 through this hearing, petitioner has worked as a licensed clinical psychologist and supervisor for a nonprofit working with convicted sex offenders. Finally, in August of this year, petitioner started as a clinical psychologist at a trauma recovery center. Petitioner CV is attached as Complainant Exhibit 7, but as stated earlier, please note that Mr. Kravitz has provided an updated resume, which we can either replace as Exhibit 7 or add as an additional exhibit. Either way, my office stipulates to its admissibility and authenticity. Why we're here today is that petitioner petitioned for early termination of probation on October 18th, 2020. We have the petition as well as other jurisdictional documents. We have, Mr. Kravitz and myself have stipulated to the authenticity and admissibility of everything that the binder contains, or I can request that they be admitted via official notice. I can defer to you, Your Honor.
Well, given that you agree, they'll come in evidence directly.
Okay. Would you like me to read them individually?
Just briefly describe them. Yes.
Okay. So in the exhibit list, we have the certificate of licensure. That's beginning at Exhibit 1, Complainant Exhibit 1, AGO 1. Exhibit 2, the Statement of Issues, beginning at AGO 2. Exhibit 3, the Order and Decision, beginning at AGO 9. Exhibit 4, the first citation in order, from 5/28/19, beginning at AGO 33. Exhibit 5, the second citation in order, from 9/30/2019, beginning at AGO 35. Exhibit 6, petitioner's petition for early termination of probation, that's AGO 37. Exhibit 7, Manmeet Ratu's CV, Curriculum Vitae, that's AGO 58. Exhibit 8, Superior Court of Contra Costa sentencing document, that's at AGO 68. Exhibit 9, the Superior Court of San Francisco's order dismissal, that's at AGO 73. Exhibit 10, the Superior Court of Alameda County's order of dismissal, that's at AGO 80. 11, the Superior Court of Alameda County's order of dismissal beginning at AGO 89. Exhibit 12, the probation report for Dr. Ratu, that is at AGO 91. Exhibit 13, the probation profile of Dr. Ratu, that is at AGO 95. Exhibit 14, it says petition early term. However, that's not very accurate. It's really just billing monitor info, but that's Exhibit 14, and that's at AGO 374. Exhibit 15, a letter from Dr. Lori, the practice and billing monitor, beginning at AGO 375. And finally, Exhibit 16, the notice of hearing, beginning at AGO 377.
Okay, thank you for identifying
Thank you.
exhibits 1 through 16 without objection or in evidence.
Thank you, Your Honor. Now, since the burden is on petitioner, we rest and wait for her to testify subject to her cross-examination. Thank you.
Okay, thank you. Mr. Kravitz, would you like me to swear in your client?
Sure, you can do that. I was going to give a brief opening statement, but
Oh,
as you want to do it, whatever procedure you want to follow.
okay, since I raised it, I'll go ahead and swear her in, and you can proceed uninterrupted after that. Dr. Ratu, would you raise your right hand, please? And do you swear or affirm under penalty of perjury that your testimony in this matter before the board will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Kravitz, please proceed with your opening statement.
Yes, I believe that the board should, of course, grant this petition for the early termination of probation. Indeed, Dr. Ratu is to be congratulated for being able to successfully start her career while on probation and comply with every issue of probation. There was 2 citations for some minor issues, which are explained in the record, but I don't really think we need to go into in any great deal. The reason she was put on probation was a legitimate concern of the board that she had a problem with alcohol, and hence they had the condition in it that she receive a psychological review. She did that, and the review determined that she did not have a current issue and that any problem she had was in remission. And of course, since she has had a license, she has had no issues whatsoever, no convictions, no arrests, and so forth, and continues in her sobriety. From a important legal issue here is that the legislature has clearly stated its intent concerning criminal conviction cases and licensure, and they modified and changed Business and Professions Code 480. Pursuant to Business and Professions Code 480, if Ms. Ratu appeared as an applicant for licensure today, under the exact same circumstances that she was in at the time of her original application, at her hearing, her license could not have been denied because at that time, all of the convictions were dismissed pursuant to 1203.4. Only one of those convictions was within the 7-year period of time necessary. And of course, today, we are in that situation completely. All of her convictions have been dismissed. Hence, if she was to apply today for licensure with the exact same criminal history, and indeed, if we change the clock and the events began the exact same amount of years before, and so forth, and she had the 1203.4s, this board could not discipline her license. They did. She's fully complied with it and worked successfully as a psychologist. And based on this and on the clear intent of the legislature to allow people to work who had prior criminal convictions, and on the fact that this board's main issue on probation was to determine whether or not she had any ongoing problem, which she does not, and she has worked for a number of years now under the board strictures with having a workplace monitor. There's no question in my mind, and I would imagine in the board's mind, that she is fully eligible for the early termination of probation. Okay. So I will introduce her and have her explain why she wants to get off of probation, and that's how I would propose to proceed.
Sounds good.
Okay. Are you there, Doctor?
Yes.
Okay, great. Why don't we start there? Could you please explain why it is you wish to get off of probation at this time?
Yes. Thank you. Before I begin, I would like to thank each of you for attending today and taking time to meet and review my request for a petition for early termination of probation. This process has been challenging and rewarding at the same time. Meeting all of the requirements over the past years, including daily alcohol check-ins, completing psychological evaluations, documentation, monitoring fees, course attendance, and maintaining communication with all involved was not always easy. I have been denied careers I was otherwise qualified for at certain hospitals and government positions because of my current probationary status. My career at the HOPE program became static and I was paid less than persons without restrictions despite my experience. When I first applied for my license in spring of 2018, I had just completed my licensing exams and postdoctorate training. I worked hard and was proud to obtain an APA internship at the world-renowned Texas Medical Center, earn recognition through several divisions and committees I was a part of, and to be one of 3 students in my entire cohort to finish a 5-year program 1 year early. I was eager to work and get started as an early career professional and put to use all of the formal education I had acquired over the many years of graduate school and professional trainings. I felt like I had finally found my calling in this world. excuse me. And I was excited and passionate to serve clients and colleagues alike. While in graduate school, I also became a certified yoga instructor with the intention to provide access to internal resources to healing psychological distress, in addition to other evidence-based theories I was learning. I was able to teach at schools, community centers, and hospitals during my pre-doc and post-doc training. I not only taught patients and members of the community, but other psychologists, psychiatrists, physicians, professors, and staff who were experiencing burnout and compassion fatigue from work. Although my why was strong back then, this process, while being on probation, has made it stronger. Each year I advance in my career. I disclosed my history with alcohol and associated criminal charges. Of course, I did this with those involved in my personal life, which took courage itself, but it was another level of commitment to my sobriety and my healing, to building courage and self-esteem when disclosing this to senior professionals. First, with my graduate department chair and academic advisor after first being accepted into the doctorate program, then each year after with practicum, internship, and postdoc supervisors. It was a reminder that I have experienced troubles and I have made poor decisions in the past. It was a reminder to practice direct communication and face problems rather than avoid the parts of myself that brought me shame and guilt. Today, I value the integrity of my practice and this profession to a standard that I may not have fully understood otherwise. I'm even more proud to stand among others who value high quality service, humanity, and one of the highest ethical standards of all professions ever. It truly is a privilege. I'm grateful to be here. Having restrictions removed will not only lift practical challenges, including career opportunities and financial hardship, but will feel like I have finally made amends with a part of my personal history that I will always acknowledge but no longer identify with. Through the support of AA, individual and group therapy, my family, colleagues, friends, my yoga and fitness community, and active daily meditation practice, I have a strong network of people and practices that hold me accountable and are all safe allies. Regardless of what happens, these support systems will maintain as an anchor to show up as I was inherently intended to be, and as I believe we all are, to love ourselves so much that self-sabotage is no longer an option. Today, I approach my work and personal life the same, in that I value relationships and life itself at a level I only wish I learned to do in those earlier years of my life. I acknowledge my weaknesses and work on cultivating healthier core beliefs every single day. This is what I teach, and it keeps me committed to maintain my strength, standard of ethics, and integrity as a psychologist. Thank you.
Mr. Kravitz, do you have any follow questions?
No.
Thank you. Mr. Yates, would you like to begin any questioning you have?
Yes, please, Your Honor. Good afternoon, Dr. Ratu. I'd like to start out by asking you a few questions about the petition you submitted. Is this your first attempt at petitioning for termination of probation?
Yes, it is.
And what led you to petitioning at this point early?
As I had mentioned, it's gotten in the way of career opportunities, being able to fully practice, given my experience. It's held me back from from advancing at the HOPE program where I was working for over 3 years. A financial hardship, it's been challenging. It costs a lot to be on probation.
Now, regarding the charges that were originally read out onto the record, are you disputing any of those charges, or do you agree with them?
I agree with all of them.
Okay. Do you accept responsibility for the actions that led to the limitations that were placed on your license?
Yes.
Do you mind explaining that?
Would to the actions, like when I was on probation?
Yeah, the actions that led to you having to be on probation.
Yes, I was drinking when I was heavily drinking at it for a long time in my life in my 20s, and I was not coping the way I should have been. I was not under, full understanding of my capacities. I was self-sabotaging. I didn't have the tools and the resources, and I wasn't committed to my growth and my potential at the time. It was that final DUI that really helped me in many ways to wake up to the life I was avoiding. It was a maladaptive coping strategy for traumas that I had experienced during that time in my life. And with the support of many people, including my own want and getting tired of my own practices, like in the past, it's just made me so much more appreciative of life and my potential. And I know that I have a lot more to offer. I've been sober since that last DUI, June 12, 2012. And I commit to that every single day. And I am in full recovery, and I feel that, people should be recognized for having been recovered and for making mistakes. And I'm working really hard to continue on this trajectory every single day.
Thank you, Doctor. And this is sort of a similar question, but just to get on the record, as you're sitting here today, do you feel remorse for your actions which led to you being put on probation?
100%, yes.
Now, are there any exact terms from the probation that you specifically want to alleviate? I know you mentioned the financial burden, but can you specifically explain what about the probation that you'd like to, get taken care of so you can have a free and clear license?
Yes. So, of course, the financial part of it, checking in daily is what costs the most, I think, at this time. And also having a full and clear license, I would be able to practice at hospitals and the VA where I have been interviewed and offered positions, but I was not able to get credentialed through that final process because they said I can always come back after my license is cleared. And I enjoy working with the Veterans Administration. I did that with Stanford and the VA Palo Alto, working with veterans and working in trauma and stress as I currently do. I'd like to serve that population. I would like to not have any limits to what I can provide in terms of services. I would like more options, and also just making amends, to my past, that it would really help me to feel more free, that I have done everything in my power to turn things around for myself. And like I said, I am grateful for this experience because it makes me so much more appreciative of this license and this committee, the ethics that we serve. It's such a privilege to be here, and it's one of the highest standards of practice in any profession, and I would love to be fully a part of it.
So going back to your statement that you were looking for certain positions with the VA and I think Stanford, was it because you were on probation that you were unable to take a job with them?
Yes, and Kaiser Hospital also.
And is that probation in general, or is it regarding any specific terms or conditions of the probation?
It's general.
Okay. Now, based on the facts of this case, I mean, would you agree that alcohol monitoring for a certain period of time was a reasonable probation for you?
Yes, to give evidence to the committee and others, even though I had already maintained sobriety for some time at the time I had petitioned or first applied. It shows evidence, and so I believe it was reasonable, yes.
Okay. And I think you said this already, but are you completely alcohol-free as of today?
Yes.
All right. And you stated that your date of sobriety was June 12, 2012?
Yes.
And congratulations. Just to be as specific as possible, have there been any slip-ups, or has it been just complete sobriety since June 12, 2012?
Complete sobriety since 2012.
All right. And you said you were attending AA meetings as well. Is that accurate?
Yes.
One second. So I know we've talked a lot about alcohol being the problem, but what I see as a bigger issue is that there was some alcohol consumption and then you got into a vehicle. You talked a little bit about some personal issues which drove the alcohol use. I mean, could you describe what caused you, besides making you repeat, I mean, what exactly caused you to drive while intoxicated? Because to me, it seems like two different issues. Does that make sense?
Yes, I was trying to maintain responsibility by going home. The last one was actually the next morning after. I did stay at a friend's house that night thinking that I would be sober enough in the morning. Another one, I had not planned to drive that day. My friend was driving. She was too intoxicated, so I ended up driving, and I got a DUI that day. And so it is two separate issues because I was not cognizant of the impact or the harm, the potential harm I was causing to other drivers on the road. I was more concerned about what was immediate, and that was me getting home, my friends getting home, and I wasn't thinking about others the way I do today.
Thank you. And I guess to follow up that long-winded question, is there any assurance that you can give the board that in the future, even if there is some sort of a relapse to your sobriety, is there any sort of assurance that you can provide that you wouldn't get into a vehicle and drive in the event that you do drink?
Sure. I mean, there's so many options today. They didn't have Uber and Lyft back then. That would be an option that many people do choose to do today, and it's a much more accepted social norm to do that. I think drinking and driving is noted to be a lot less tolerated in our society, where at that time, with the people I was associating with, my environment, I was living in a town where all of my circle of my friends, I called them at the time, they were my associates, everyone was getting a DUI. That was part of my social norm at the time, but I've since moved from that community. I maintain a very small social circle of good friends. None of my friends drank, none of my close friends drank, we're all sober. And my family holds me accountable, but I do care about the impact the harm that I could cause other people.
And now I wanted to move on to your probation report. It seems that you got 2 citations. Can you explain what happened?
Yes. So the first one that was noted when I did not pay the annual fee on time. I had moved, and although I updated my address, my mailing address in the Breeze website, I did not realize that there were 2 areas that you have to update your address. So the address of record was not updated. And so I wasn't working when I first applied, so I didn't have the funds to pay for it up front, as I have been since. Now that I've been working, I've been able to pay it all off in the front. But I had planned to make payments, and there were so many requirements that I had put that as it wasn't an immediate priority at the time. And the date came and went, and the board told me that they had notified me, but I never received any reminders. And so I tried to appeal it, and I went all the way to Sacramento. I met with Mr. Gardner, my probation coordinator, and there was someone else there, and they still denied it. I was charged another $1,000 on top of it. At that time, I borrowed the money from my family, and I was able to pay it off. And since then, I was also able to find work. So I've been continuing to pay it off up front. The second one was in February of 2019, and I check in every single day. I don't think I've ever missed a day for my alcohol check-in, and that day I was called in, and I was working until 8 o'clock at night, and there were 2 places on the list that were available to go to, and so I called the first one that I was planning to go to, and they denied testing me because there was not a female to test me, and I told them I don't care. It's a medical thing. I don't care. They would not test me because there was only a man available to test. The second place, they would not answer the phone. So I emailed Mr. Gardner that evening, and I had explained what happened to, if there was anything I can do. And so I was violated for not completing the testing for that day.
Okay. Now, I noticed that prior to starting your probation, it tolled for 2 months. Is there any reason why that occurred?
Prior to starting probation?
Yeah, it looked like
Mr.
Sorry to interrupt.
No, Mr. Gardner, do you remember why it was told? Is Mr. Gardner here?
I am here.
Coordinator?
I am here. I'm just not certain if I'm able to testify at this moment.
Oh.
Yeah, unfortunately, he can at the moment, but if you don't recall why, that's fine. You can just let us know that.
Okay.
And so you don't recall why the probation told?
I don't. Maybe
okay.
It was, I'm not sure.
Now, other than the 2 citations that we just talked about, have you had any other disciplinary or non-compliance issues with the board during probation?
No.
Have you had any other criminal issues that occurred during your probation?
No.
Have you had any civil issues or substantial patient complaints that occurred during probation?
No.
So moving on to your letters of recommendation, which I believe starts on Exhibit 15. Who is Christina Laurie?
That was my practice monitor and supervisor at the HOPE program.
Okay, and how did you become acquainted with her?
She was my supervisor.
Okay, she came in as your supervisor, or you applied under her?
When I got the position, she was assigned as my supervisor.
Okay, and has she had the opportunity to review or familiarize herself with the charges that were filed against you?
Yes, she completed quarterly documents during my time.
Right. So she's aware of your probationary terms?
Yes.
All right. And moving on to PV Van Oot, is that right?
Yes, Dr. Peter Van Oot.
Okay. How did you become acquainted with him?
He was a professor at John F. Kennedy University.
Okay. And was he a billing monitor as well?
He was a practice monitor for me while I was working at Stanford.
Okay.
I hired him.
And you hired him?
Yes.
Okay. Was there any overlap, or do you mind just telling us the dates of when Dr. Van Oot was your monitor and when Christina Laurie was your monitor?
Yes. So Dr. Laurie was my monitor from 2019. And Dr. Van Oot was, so that was Stanford, 2018 to 2021.
Okay. And other than as a billing practice monitor, did you have a social relationship or any sort of outside relationship with either of those two?
No.
And did Dr. Van Oot have the opportunity to review and address the probationary terms?
Yes.
All right. Now, moving on to your CV, there was a CV that was provided earlier today by your attorney. Is that a true and accurate version of your CV?
Yes.
Okay. Now, also, you also are required to take some coursework as part of your probation. Can you describe that for us?
Yes, I took ethics coursework and continuing education, 12 units every year. I completed that, and that was all submitted.
And is there anything you learned specifically from any of that coursework that assisted you in your practice?
It reinforced what I learned prior during graduate school and about law and ethics. The continuing education units are always reinforcing what I'm learning and teaching in cognitive behavioral therapy, compassion focused trauma work.
Okay, so then I'll move on to your probation file. That's going to be Exhibit 13. You don't have to review all of it, but did you have the opportunity to review all those exhibits that everyone's currently reviewing at the moment?
If by the number, I wouldn't know exactly which one you're looking at, Exhibit 13.
I believe it's a probation file that was included.
Yes.
I believe you provided that. Is there anything inaccurate in that probation file, or is there anything that should have been included that hasn't been?
No.
And I reviewed it. It appears to me that you haven't had any probation violations other than the above mentioned citations. Is that accurate?
Yes.
All right. And are there any other issues regarding the probation file that you'd like us to know about?
No.
Okay. We'll move on to your work with support groups. I think you mentioned, we know support groups are a requirement of your work, a requirement of your probation. Is that correct?
AA has been, yes.
Okay. Is that the only support group you've been going to?
Currently, yes.
Okay.
I had attended support groups prior.
Can you tell us what support groups and when?
Sure. I was in a women's recovery group in 2012, 13, I think, through 14. And I've attended 3 years of individual therapy during that time. It started 2013 through 2016.
As far as your probation goes, since the time of your probation, has AA been the sole support group that you've been involved with?
Yes. as far
Okay.
as alcohol related directly, but of course I have other types of support.
Right. And that's a requirement of your probation, correct?
Yes,
How often do you attend those AA meetings?
once a week.
Once a week. Do you intend to continue AA if your probation is lifted?
Yes.
Now, I just had a few more follow-up questions before wrapping up. Now, this is a petition for early termination of probation, right?
Yes.
Now, in the event the board is unwilling to grant your petition, do you have any requests for modification?
I'm not sure if we can modify anything, but I mean, the cost is what has been the most challenging, the finances. So if there's anything that can be done about that.
Okay. And with that, I don't believe I have any further questions. Thank you very much, Doctor.
Thank you.
Thank you, Mr. Yates. At this time, I'd like to invite board members to ask any questions they might have, beginning with Board President Dr. Tate.
Hello, Dr. Ratu. Thank you for meeting with us today. I have one question for you. I just heard that you will be attending AA once a week, or you're currently doing that and intend to do that later. Is there any other active treatment you're in at this time?
Not specific treatment, no.
Okay, thank you.
And Vice President Say Ron Fu.
Thank you so much, Your Honor, and thank you, Dr. Ratu, for your time
Thank you.
today. I just have one question. You mentioned, I'm curious to hear from you if, in addition to or aside from the inconvenience of probation, if you thought probation was warranted when the board made its decision.
It was warranted given my prior history. Yes, I had 4 drunk driving cases. I would be concerned.
Understood. Thank you so much, Dr. Ratu. I really appreciate it. Thank you, Your Honor.
And Dr. Kasuga.
Thank you, Your Honor. And thank you, Dr. Ratu, for appearing before us and testifying today. I just have one question. What has been most helpful for you in keeping sober and coping with cravings, if there's any?
Yes, thank you. I would say it's multifaceted, honestly. It's been, first was me wanting and being ready to change. Outside of that, having the accountability and support of AA and therapy, individual and group, my family's unconditional love and support throughout this process. I have a yoga and fitness community. I compete in competitions, so having their support, everyone that I associate with is healthy and sober. So I have accountability on all ends, and I have multiple sources of support. So it's hard to say it was just one thing.
Okay, thank you, and congratulations on what you've accomplished since your sobriety. Thank you.
Thank you.
Thank you. And Dr. Cervantes.
Thank you, Your Honor, and thank you, Dr. Ratu. I don't have any questions at this time.
All right, thank you. And Dr. Sheets.
Yes, I echo congratulations to you also, Dr. Ratu. I have a couple of things. You were asked about the 2-month tolling, and I wonder, was that at the beginning of the probation until you were determined to be safe to practice. I saw a letter, something like that in the packet from.
Possibly, yes. Yeah, I believe so.
Okay, I just wanted to clarify that. And what can you tell us about, if you look back at the various stresses that you were under and at that time made choices to use alcohol in a problematic way, and what could you tell us about if you were facing similar stresses today, or perhaps if you had a client who was facing similar stresses, what could you share with us about what kinds of alternate choices people could make that would be healthy choices in those situations?
And so thank you for asking that. I think about myself often when I have clients that have been in similar situations, and I ask them to understand what it means to really love yourself and to have compassion for yourself. It's a big part of my work. I did not have compassion for myself, and therefore I self-sabotaged all the time. I would encourage them to find sources of support, have a strong social network of people who can hold them accountable in a compassionate way. Having groups, AA, has been really helpful. Individual therapy, having someone to talk to develop insight onto what it is that's been problematic, and how to cope. Also learning to be an assertive communicator. I was very passive in terms of my communication style early in my life, and that was conditioning through culture and just my role in the family. And I was, in an arranged marriage at the time that was abusive, and I didn't have the strategies or the people to talk to at the time. I didn't know how to talk. I didn't know how to ask for help. So also encouraging them to find safe allies and people that they trust to share their experiences with, and know that there's always a way out. That not to feel defeated. I felt very isolated for a while in that time in my life. I was didn't have the strategies. I didn't know that there was anything different, that there could be things could be different. And so I would encourage them to use all of that.
Thank you so much for that response. That was very helpful.
Sure.
That's it for me.
Thank you. Board Member Julie Nystrom.
Yes, thank you, Dr. Ratu, for being with us today and for answering our questions. I'm interested in if there are any portions of your probation that if we grant early termination, that you would miss, or that have been helpful to you, and get your perspective on that.
I don't know if I would miss anything. It would, it's helped, of course, to just hold me accountable in a different way. But at the same time, this is a path. This is who I am today, and so it wouldn't change that. But as far as the real reason one of the main reasons is just to open up options in terms of my career and making amends with my past. And so that would be, it feels like a cloud almost that's still haunting me from my past. And but still, I acknowledge it. It's a part of me. It's a part of my history, and I'm not going to avoid it or ignore it. And I understand why I was given probation in the first place. And as far as missing it, to be honest, of course, it's been challenging to check in every day and quarterly documents and making sure all of my I's are dotted, T's are crossed amongst all of my other responsibilities of daily life. And so it would free that up for me.
Okay, I appreciate that response. And I mean, maybe miss it wasn't the correct term. But I think more I was, seeing, how helpful, to be responsible and to check in and hold yourself accountable. And I feel like you answered that for me. And so thank you for answering my questions. And that's all I have.
Thank you.
Mr. Phillips? I should have
Yes,
said
sir.
Dr. Phillips, excuse me.
That's okay. I've been called worse. I just have a few questions for you, Dr. Ratu, and again, congratulations on your sobriety. It's always gratifying, excuse me, to see people that have benefited from, recovery. Do you consider yourself an alcoholic?
Yes.
And in AA, do you have a sponsor?
No.
Have you ever had a sponsor?
No.
Have you ever worked the 12 steps?
Yes.
You have. Who did you work the 12 steps with?
So I worked when I was attending more frequently, 3 times a week. I was working in a women's group with her, and her name was Denise. I honestly don't remember her last name.
That's
it was
okay.
in
We'll
Walnut
keep her,
Creek,
we'll keep her
California.
anonymity. But Denise supervised you in doing the steps?
Yes.
Okay. Appreciate that. To ask you, so you intend to continue to attend AA, is that correct?
Yes.
On a weekly basis?
Yes.
I'm a little curious. It appears that earlier in your probation, according to the probation report, you made a request for modification of the terms. Recall that?
Yes.
And part of the modification of the terms you wanted beyond being released from the substance abuse testing, you also wanted to be released from the obligation to attend AA on a weekly basis.
Yes.
So I'm kind of confused between the two.
Yeah. Thank you. So I had initially requested to be released from that because I was overwhelmed with a lot going on in my life, and I had since found some groups that have been helpful, and I realized that it's nice to check in. It's just once a week, and it's over the phone now. It's a lot easier rather than attending in person, and it was more responsibilities. I had a lot going on, and it was overwhelming given everything else that was going on at the time. But I feel like it is a good part. It's a healthy thing to have as a part of my life, to check in and help others who are earlier in their own sobriety journey.
Right. Do you sponsor anybody in the program?
No.
Okay. So you're saying you made the request for modification because you wanted it then, but you wouldn't necessarily want that modification now.
Yes.
Okay. Was that a confusing question? I want to make sure you don't feel like your answer.
So the check-in was because it was mostly because it costs over $400 a month.
But that's the drug and alcohol testing, correct?
Yeah, for the testing. Yeah.
I'm just talking about the AA meetings.
Yeah.
You wanted a modification as to the AA meetings, and that's no longer of concern to you.
Yes.
Okay. Very good. You said you've taught courses and appeared at conferences and gave presentations and so on and so forth.
Yeah.
I think that's also indicated in your resume.
In my CV.
Yeah. Were any of those offered for continuing education credits?
No.
Okay. And you understand there was a prohibition against you teaching continuing education courses?
Yes.
Okay. There's also a prohibition against you doing supervision in your probation, in the order and decision. Is that correct?
Yes.
And you have been supervising people, haven't you?
I supervise students.
Well, they're trainees, aren't they?
They're trainees. Yeah. So not postdocs. I'm not allowed to train interns or postdocs.
Yeah, actually, if we were to refer back to the original decision and order, see if I can find the right page for you. It may be page 22, HEO 22, fact, I think is contained in exhibit number 3. Do you have the documents?
I don't have it in front of me, no.
Okay, I'm going to read you a section there and see what your understanding of the language is. So
Okay.
I'm a little bit confused about your supervision. I've got to get to the right page. Excuse me while I scroll. Okay. So the section is 16, and I'm going to read it to you. I'm sure your attorney can verify that I'm reading it. Employment and supervision of trainees. If respondent is licensed as a psychologist, she shall not employ or supervise or apply to employ or supervise psychological assistants, interns, or trainees.
Yes.
So you're telling me your understanding was that prohibition didn't apply to what you're doing?
So they were, my Dr. Lori had me supervise master's level trainees. They're practicum students.
So they were trainees.
They were practicum students. So she said that on my probation, I'm not allowed to supervise psychological assistants, interns, or postdocs.
Yeah, that's not quite the exact language, but so that was where the misunderstanding came in. You relied on her to interpret the decision?
Yes.
Okay,
I
I'm
had
curious.
two students.
Yeah, and the fact is you were supervising was mentioned throughout your probation monitor reports, the letters that you submitted,
Yes.
even the original resume that you sent us under
Yes.
Project Hope. You indicated that you'd supervise students.
Yes.
And today you produced a new resume, correct?
I updated it because I stopped working at the Hope program, and I noticed that the other one.
So that was the only reason that you updated it?
Yeah, I just made it more current, and then I added a couple of things, responsibilities under Trauma and Stress Recovery Center. I just clarified the population, that they're workmen's comp population, police officers, first responders. There were minor changes.
Yeah, one of those changes was under the Hope program. You dropped the sentence about supervising students, didn't you?
No, I didn't change anything when it came to that.
Well, if you compare the two documents, one of them references supervising students and one of them doesn't.
Huh.
And the more recent one doesn't. Was that intentional on your part?
No, I don't see, because I didn't change. Let me look at that. No. Can you say which bullet point it was? What number?
Yeah, let me get you the right document so that you can refer.
Yeah.
Got a confusing number of screens open, particularly in my PDF. For 1 sec. I think it's exhibit number 7.
Mm-hmm.
That would start at AGO 58.
I'm not sure.
You see where at the last entry under the Hope program it says supervised doctoral students, including monitoring caseload, approving artifacts, oversee clinical operations, and evaluate professional development.
On the previous one? Because I have
the previous one.
Current,
the previous one.
Yeah.
You don't have that in front of you.
No, I have the new one, the updated one. I don't know how that changed.
You also changed the title of your job on that particular entry, where it said licensed clinical psychologist and supervisor. You changed it to forensic mental health psychologist.
Oh, okay. So you're looking at one that I probably had when I first applied?
I suspect you submitted it with the original petition.
Okay. Okay.
So you weren't trying to intentionally obscure that fact from us?
No, it was, no, absolutely not. Yeah, all of my responsibilities were documented on my quarterly reports.
Well, thank you
I
very
was probably
much.
just trying to clear it up a little. I'm not sure what happened.
Okey-dokey. Thank you very much.
Sure.
Board Member Anna Riscati, do you have any questions?
No, I don't have any questions. Thank you.
Finally, Dr. Rogers, same question.
No questions on my end. Thank you so much.
All right. Unless I'm interrupted by any board member who has an additional question, and I hear no such indication, I'd like to move at this time to closing statements. I'll invite first Mr. Kravitz, if you'd like to make any comments in closing to the board members.
Yes, certainly. As we've heard, Dr. Ratu is fully capable of practicing without any further probationary conditions. This board in particular, the Board of Psychology, is based on the theory that people can change through time. And in this case, that's exactly what's happened. In a sense, to deny her the petition for early termination would be to say that your own standards of putting people on probation are ineffective, and that treatment for people with alcohol problems are ineffective, that the reports of psychologists that are relied upon to determine if people have such problems are meaningless, because all of those things are in evidence. We have a report from someone who's been reviewed and so forth, and she's worked successfully for a number of years while on therapy. So obviously she is, a model candidate for the early termination of probation. As I stated at the outset, from a legal point of view, she would not be on probation if she applied now, which is certainly a factor that should be considered in the theory of justice and equal treatment under the law. It is a fact that many criminal courts, because of changes in probation, are allowing people to petition for early terminations of their criminal probation after a year, even when they were sentenced for 3 years, because the new law is that after 1 year you can petition, and this is a fact that is happening and so forth. And this board should follow the guidance of the legislature in that way. But moreover, this person, Dr. Ratu, is fully reformed and has been working for many years successfully, wants to continue her career without the onus of probation. The issue you should know is that one of the issues is that the Veterans Administration, as a matter of law, does not allow people to work at the VA in any capacity if they have any restrictions on their license. I've litigated this issue many times. It's not that you apply and they say you can't work here. It's actually in the rules and regulations of the federal government prohibiting them from doing so. So I believe and I hope that this board will allow Dr. Ratu to continue her career, continue helping members of the community to her full capacity by releasing her from probation. And she can continue to be an excellent example of the success of people overcoming alcohol problems and overcoming psychological problems to lead a healthy and productive life.
Thank you, Mr. Kravitz. And finally, Mr. Yates, would you like to make any comments by way of closing?
Sorry, was I muted?
You must have been muted. You might want to
Oh.
start again.
Sorry, Your Honor. At this point, we submit with nothing further.
All right. Well, thank you, everybody. The board appreciates your time. This matter is now submitted and the record is closed. The board will go into closed session this afternoon. A decision will issue hopefully in a matter of weeks. Thank you, and off the record. And I turn it now to Board President Dr. Tate. Is it your pleasure to take a break until the next hearing or something else?
I'm thinking that we should take a break and just take a 15-minute break and go into the next petition hearing at 3 o'clock. and go into closed session and discuss both cases after. I have 3 o'clock on my computer. Welcome back. Can we please call the roll?
Oh, this is the moderator. Let me unpause the recording real quick. It'll give a little announcement.
Okay.
This meeting
thanks.
is being recorded.
Thank you. I keep making that same mistake. It's 3 o'clock and we are ready to resume agenda item number 9. But before so, can we please call the roll?
Yes. Kasuga.
Here.
Cervantes.
Here.
Fu.
Here.
Harb Sheets.
Here.
Nystrom.
Here.
Phillips.
Here.
Riscate.
Here.
Rogers.
Here.
Tate.
Here.
Roll is complete.
Perfect. Thank you so much. Agenda item number 9 is a petition hearing, and I am just perusing. I see Judge Liu. I don't see.
This is the moderator. I believe one of the call-in users that we have in our attendees may be our petitioner.
Yes.
So I'm going to unmute them just to confirm.
Yes, Anthony Sabatasso here.
Wonderful. Let me promote you up to panelist. And then because you're audio only, if you want to mute yourself or unmute, you'll click *6 on your device.
Okay.
Thank you. I see Deputy Attorney General Yates, but I do not see Mr. Lent.
I'm present.
Oh, okay. Sorry about that. And the court reporter, is that?
Yes, I'm here.
Okay, perfect. Judge Liu, you have the floor.
Okay, thank you very much. Well, good afternoon, and we are now doing our third of 3 petition hearings. The petitioner is Dr. Anthony Sabatasso, who is with us by telephone. Dr. Sabatasso, we're all actually doing this audio only. It's worked quite well. If at any point there are technical difficulties, hearing or whatever, just so indicate and our moderator will assist us. I want to clarify quickly who will be representing the Department of Justice in this matter.
Deputy Attorney General Aaron Lent.
Thank you, Mr. Lim. All right, I'm going to go on the record at this time. And we are hearing, as I indicated, a petition for reinstatement of a surrendered license. The petitioner is Anthony Sabatasso, PhD. This has the board's case number 600-2020-000110. It also has the Office of Administrative Hearings case number 2021-120640. This matter was noticed to be heard on the 17th of February at 3 o'clock. It is being heard before the full Board of Psychology. All members are present. Mr. Aaron Lent will be representing the Department of Justice. And Dr. Sabatasso, this is the format that we'll be following. I'm going to ask Mr. Lent to provide board members a history and procedures up to today's date. The record in this case will also be identified. I believe you'll find that all the matters that have been filed before the board are also with you. Board members have by now already reviewed these materials. After he provides that overview, I'm going to invite you, Dr. Sabatasso, to make a statement to the board in support of your petition for reinstatement. And following your opening comments, I will ask Mr. Lent to elicit more information from you by way of questions relevant to the board's consideration. When Mr. Lent is complete, I will ask board members individually if they have any follow-up questions. And when that period is done, we'll then go into closing statements. The board intends to meet in closed session today to consider the matters that they hear in today's hearing. They will then issue a decision, hopefully in several weeks' time. During the course of this hearing, if you have any questions, if you have any difficulties hearing or anything that you want to raise, just please interrupt and we'll go forward from there. My name, by the way, is Jonathan Liu. I'm an administrative law judge. I signed with the Office of Administrative Hearings, and we assist this and many, many other boards in conducting hearings such as this. Having gone over all that, I'd like to now invite Mr. Lent to provide board members with a history and overview of this case.
Thank you, Your Honor. Good afternoon. My name is Deputy Attorney General Aaron Lent. I'm appearing on behalf of the Attorney General of the state of California. Just as earlier, I'm here to assist Your Honor and the board members in this fact-finding hearing. My role is not adversarial, but rather is intended to protect the public interest and ensure that Your Honor and the board members have adequate information to make an informed decision in this matter. For the record, both the petitioner and the Attorney General's office waived their rights for an in-person hearing in which to proceed with the petition today by way of telephonic audio only. I will now ask that exhibits A through G, as identified in the 3-page exhibit list that are bait stamp numbered 1 through 296, be marked and entered into evidence. Dr. Anthony Peter Sabatasso has petitioned for a reinstatement of his surrendered California psychologist license, which was originally issued on December 1st, 1977. The surrender of the petitioner's license became effective March 2nd, 2014. On July 30th, 2007, the California Board of Psychology received an email from the Florida State Department of Health. The email stated that petitioner had a pending application for a psychology license within the state of Florida, and during a preliminary investigation by the Florida Department of Health, a newspaper article from the Miami Herald was discovered, which detailed petitioner's arrest for giving a prostitute the painkiller narcotic hydrocodone, a Schedule II controlled substance. The email from the Florida Department of Health was accompanied by the July 28, 2007 Miami Herald article, as well as the Hollywood Police Department incident report. Based on these circumstances, the Medical Board of California opened an investigation and assigned an investigator who obtained statements from the petitioner, incident and arrest reports from the Hollywood Police Department, correspondences from the Florida State Department of Health and the Board of Psychology, as well as Broward County courthouse records, and retained the services of an expert who reviewed the documents and opined as to the petitioner's departures from the standard of care. On July 21st, 2010, the California Board of Psychology filed accusation case number 1F-2007-185372 against the petitioner, alleging 4 separate causes for discipline. The first, use of a controlled substance in a manner dangerous to self or others. The second, misrepresenting status as a licensed psychologist. The third, dishonesty. And the fourth, conviction of a crime substantially related to the practice of psychology. The factual basis of these allegations articulated in that accusation state that petitioner was residing in the state of Florida without being licensed to practice psychology in Florida. And that on July 12th of 2007, at approximately 8 p.m., a Hollywood Police Department officer observed the petitioner, an adult female, sitting in a parked car. After approximately 5 minutes of observation, the officer then saw the female exit the vehicle, who he then recognized as a known prostitute and had prior personal knowledge that an hour earlier, 2 other police officers had warned the female against soliciting prostitution in that same area. As the officer approached the female in the vehicle, he observed a blue pill fall from her right hand onto the ground. The officer retrieved the pill, which he identified as hydrocodone, but which the female claimed was merely ibuprofen that was given to her by the adult male driver of the vehicle she had just exited from. The adult male driver of the vehicle was identified as the petitioner. Officers spoke with the female prostitute separate and apart from the petitioner. She informed the officers that the petitioner gave her the blue pill and told her it was a pain pill, which she then claimed she thought was ibuprofen. She also told police officers that the petitioner was a regular prostitution client of hers. When initially confronted by the officers separate and apart from the female prostitute, petitioner stated that he was a psychologist and that he was counseling the female. Petitioner also claimed that he was trying to put together a court program for drug addicts. When asked, petitioner admitted to giving the female hydrocodone, which he stated he knew was a controlled substance, but did so in what he described as a humanitarian gesture. When confronted with the statement by the female that petitioner was a regular prostitution client of hers, the petitioner did not deny having engaged in acts of prostitution with her, nor did he fully admit to having a prostitute-client relationship with her. During a search of the petitioner's person, a black fanny pack was located on him, which contained a variety over 100 loose pills without properly labeled prescription containers. Petitioner claimed to have prescriptions for all of these. When asked, petitioner stated that some of the pills were obtained from Mexico via online sources. The pills included, but were not limited to, the following: Xanax, which is a Schedule IV controlled substance, as well as Schedule IV, my apologies. Hydrocodone, which is a generic name for Vicodin, Narco, or Lortec, and is classified as an opiate analgesic combination product used to treat moderate and severe pain. Prior to October of 2014, it was a Schedule III controlled substance. However, it is now classified as a Schedule II controlled substance. Soma. Soma is a centrally active skeletal and muscle relaxant and is classified as a Schedule IV controlled substance. Wellbutrin, which is an antidepressant. Zorvaxon, which is a medication that is used to treat outbreak of genital herpes infections. Ultram, which is an opioid pain medication, also a Schedule IV controlled substance. Tramadol, an opiate pain medication used to treat moderate and severe pain, also a Schedule IV controlled substance. And Carisprotol, which is a central acting skeletal muscle relaxant, also a Schedule IV drug. The petitioner was arrested and then transported to the Hollywood Police Department and interviewed by a detective. The petitioner claimed to be a psychologist and stated that he frequented the area seeking out prostitutes to quote-unquote counsel. During the interview, petitioner admitted to picking up the female who he knew was a known prostitute, but claimed he only wanted to talk with her and get her some food. Petitioner told the detective that the fanny pack and the pills were his, and that he gave the female prostitute hydrocodone during their encounter that evening. On or about August 9, 2007, a 4-count criminal information was filed against the petitioner in the Broward County Circuit Court, which charged the petitioner with these 4 crimes: trafficking in hydrocodone, unlawful delivery of hydrocodone, unlawful possession of Xanax, and unlawful possession of Soma. On or about June 27, 2008, petitioner entered a plea of no contest to count 2, the unlawful delivery of hydrocodone, a second-degree felony. The judge in the case exercised his discretion and ordered the petitioner to complete an 18-month probation with various terms and conditions in lieu of serving a time in prison. Accusation case number 1F-2007-185372 resulted in the executed stipulated surrender of license and disciplinary order on or about November 4, 2013, whereby petitioner stipulated and agreed that there was a factual basis for both the first and fourth causes of discipline. The first being the use of the controlled substance in a manner dangerous to self or others, and the fourth cause being a conviction of a crime substantially related to the practice of psychology. Those charges constituted causes of discipline. Further, petitioner stipulated and agreed to give up his right to contest that cause for discipline on those bases. The order from accusation case number 1F-2007-185372 states that petitioner ever files a petition for reinstatement, as he has done here, all of the charges and allegations contained within the first and fourth causes of discipline in that accusation shall be deemed true and correct and admitted by petitioner when the board determines whether or not to grant or deny the petition. It also stipulates and orders the petitioner to pay the board its costs of investigation and enforcement in the amount of $7,000 prior to the reinstatement of his license. As previously stated, the effective date of the board's decision and order was March 2nd, 2014. On February 4th of 2020, the board received an incomplete petition for reinstatement of surrender license application from the petitioner. The packet was missing a disciplinary action sheet, evidence of rehabilitation sheet, and a lack of contact information on the copy of the Board of Psychology disciplinary decision authorization for release information. On March 18th of 2020, the board received a letter from the petitioner with attachments that included the petitioner's responses to the questions on the disciplinary action sheet. The rehabilitation sheet was again left blank, as was the disciplinary action sheet by the petitioner, and no copy of his prior disciplinary action was included. On August 24th of 2020, the board received a letter from the petitioner with attachments. However, petitioner again neglected to include a copy of the Board of Psychology disciplinary decision and failed to include a proof of completion of continuing education, as well as the agency copy of the live scan form. On October 28th, 2020, the board received a letter with attachments from petitioner, which included these missing documents. On July 23rd of 2021, Special Investigator Nicole Walker conducted a telephonic interview of the petitioner. On November 24th, 2021, Special Investigator Nicole Walker conducted a telephonic interview of petitioner's psychiatrist, Abby Strauss. On December 6th, 2021, Special Investigator Nicole Walker authored an investigative report in this matter and attached all the items of evidence she obtained during the course of her investigation, which is reflected in Exhibits A through G. I believe that accurately summarizes the matter as of today's date, and as this is a petition for penalty relief and reinstatement of a surrendered license, it is the petitioner's burden to demonstrate that he is rehabilitated by clear and convincing evidence. Therefore, I have nothing further at this time. However, I do reserve the right to cross-examine the petitioner or call him as a witness if he does not choose to testify before making a recommendation to this board.
Thank you, Mr. Lanton. Let me indicate that Exhibits A through G are in evidence.
Thank you, Your Honor.
Dr. Sabatasel, before we proceed, I'd like to administer an oath to you. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the board will be the truth, the whole truth, and nothing but the truth? I didn't hear you. It could be that your mute is on still. Please unmute yourself. Moderator, can you confirm whether or not we are still connected to Dr. Sabatasel?
This is the moderator. I sent a request to unmute his microphone.
Okay, yes, I'm here.
All right. Doctor, did you hear me administer an oath to you just now?
I'm sorry, a call came in on my phone and I didn't hear it.
All right. I'm going to administer an oath before you testify before the board. Please raise your right hand.
Okay.
And do you swear or affirm under penalty of perjury that the testimony you are about to give to the board will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Doctor, this is now your opportunity to testify on your own behalf. You are reminded that the board does have the benefit of your petition package, so there's no need to repeat everything in detail, but rather focus on those matters that you would like to highlight for this board and also provide information to the board in support of your petition at this time for reinstatement of your surrendered license. You may proceed.
Okay, thank you. I guess I should have written a response to this board, but I'm going to just testify to the truth because I'm the only one that was there at the time, and that's the only reality that I know. I guess I was advised not to talk about the incident since it's 15 years ago, and I've already admitted to most of what has been recorded. Unfortunately, the contextualization of the events, as I stated before in what I wrote, were interestingly distorted. So I can't help but say a few things to clarify these events. Having come to Florida, I had retired and was operating as a non-licensed psychologist, although I had my license in California. And I closed my practice in Southern Marin after some 30 years there, and put away my records and traveled to Florida and wound up falling in love and relocating here. I also, prior to that, relocated to Guerneville. I was working, so to speak, with street homeless, trying to get them off the streets of Guerneville. And I was coordinating my efforts with the Russian River Counseling Center under the auspices of the former board chairman, Tony Madrid, up in Guerneville. Then moving to Florida, I continued my work with the homeless. I actually, just before my arrest, had just finished a paper for the American College of Forensic Psychology on suddenly homeless following the resident hotel fires in San Francisco. I'm both a member and board member of the American College of Forensic Psychologists, so I hold myself out as a clinical and forensic psychologist. But essentially, on the streets of South Florida, you could call me a street psychologist, but I'm not, wasn't holding myself out as anybody's psychologist, nor was I obviously doing any therapy with anybody who was on the streets, because everybody had a first name basis, and my goal was to get people off the streets and into either recovery or shelter. And that was essentially my motivation. The greatest joy was getting somebody off the streets and into some sort of recovery. And at some instances where I've saved a few people's lives. The problem that I had initially was I did not carry my license with me on working in the streets. And when somebody was needing to be Baker Acted, I couldn't prove that I was a psychologist from California because I didn't carry my board ID papers regarding my license or status, so I was disregarded. I started carrying my license, and I had one incident where a woman had become a danger to herself. She had breast cancer, and I told her that I'm going to call 911 and get her off the streets, and did, in fact, get her off the streets. Her mother actually was a OBGYN here in South Florida, and they took her to Baptist Hospital, performed surgery on her, and she sung the praises of Dr. Tony throughout the hospital. So, in essence, my work has been with the homeless, trying to get them in some degree of recovery. The events regarding my arrests were just as, I guess, interesting as one way to put it. That involved me on my way back to San Francisco in 2007. We're talking 15 years ago, when I was looking for homeless people to say goodbye to. I was working initially in Miami-Dade, which things were very comfortable there, and there was no issues regarding people working there. They didn't mind somebody helping the homeless. But when I moved to Broward County working there, most of the homeless people were street prostitutes, and they were on the streets. And there was no little conglomerate of people who were under trees where you could work with them or talk with them or talk about getting off the streets. So on the night that I was, or afternoon, I had just finished a long bike ride. I was in my car looking for homeless people, and I pulled up to a location where homeless people had gathered, and a police officer was on the corner. And while I pulled up, a street prostitute I was somewhat familiar with leaped into my car and pulled out a piece of yellow paper. When the police officer says, "What's going on?" And I said, "What's going on?" And she held up the piece of paper saying, "I've already been counseled to leave." And he turned to me and said, "Take her home." So the comment saying that I picked up a street prostitute in this occasion was not accurate. Not to say that I wouldn't have stopped and talked to a street prostitute, but this woman was a one-woman crime wave. And as you can see from the arrest record, she has now over 647 arrests. There was no way I could work with her or help her, nor did I feel that I had the skills to. And I avoided working with her. And when he said take her home, the better judgment should have been that I got out of the car and simply said, I'm not gonna do this. You know, this is not my job. But I acquiesced to it, and the rest of the story was I took her to get something to eat. She was intoxicated. She couldn't get home. Long story short, we were on the side of the road where I said, look, you're going to have to get out in a public place because I don't want you using my phone to call drug dealers. Because I was going to take her to Baptist Hospital, and I saw she was in a diabetic crisis. Anyhow, she couldn't get out of the car, and I wound up with poor judgment offering her a pain medication because she said she was in pain. And I said, well, go ahead and take this. And she says, I don't take that anymore. I actually have a problem with that. And she wound up throwing it on the street as she exited the car. And the police officer finally came up because we were in a public place. And the story was that she saw herself as getting out of trouble by doing this. In fact, when the police officer came up and saw that I was sitting there, he asked me, what are you two doing there? Implying the question, meaning, are you two engaged in drug dealing or something? Because I had California license plate, I stuck out like a sore thumb. And the arrest that took place involved the fact that I loosely kept all my pills in my fanny pack, and my prescriptions had just been filled because I was headed back to San Francisco for the Summer of Love, and I didn't want to get any waste of time trying to fill prescriptions in San Francisco, which makes it difficult. I went back every summer, and I wound up just having filled my prescriptions, and they were in the front seat of my car. And all those charges were dropped eventually. But going back to errors in judgment, this has been 15 years ago, and I've had plenty of time to be traumatized and frightened by my lack of judgment and my risk-taking behavior. I guess things are fine until they are not fine. And that arrest obviously ended my career in helping the homeless, period. And everybody that saw the case suddenly put all their medications out of their pockets and put them back in their pill bottles where they're supposed to be. Well, there's a variety of medications in that fanny pack. They were there for ages, and the only medications that I was on were those that I was regularly using, all of which were monitored by physicians and continue to be. I was never accused of drug abuse or any sort of misuse of medications. And today, in terms of the pain management in America, they've gotten pain clinics, so they require people to be urine tested to make sure that they're compliant with whatever prescriptions they're on. As at this point, means dropping urines within every 6 months. So I've never had a bad urine test, and that's standard protocol for pain clinics in South Florida, anyhow. Excuse me. All right. Excuse me. As we speak, I've been under care for a pain injury that I've had in '78 when I was hit by a dump truck, and it's evolved over the decades in terms of what medications I was on. Right now, all prescriptions are monitored by by 4 separate agencies: the pain clinic, the pharmacy, the insurance carrier, and of course the patient themselves. To me, I've never had a problem with pain or medication. And going back to this event, the officer that came up following the arresting officer said, "We can see that you're not a street person. What we'll do is we will let you go under the fact that you offered her as a humanitarian gesture, a pain pill, because you saw her in pain, and she was a crippled woman who was in diabetic crisis. And you'll be protected by the Good Samaritan Act if you agree to admit that you gave her the pill. I said, well, of course. Where else would she get it? And it was poor judgment on my part. The mistakes were just unending. I was in the process of working with the judge, Stephen Leifman, of the drug court, to get oriented as to how best to work with drug addicts on the street. After the arrest, I called him and I said, I understand this happened to you once. And he said, yes, but I had a badge. I said, what's a badge? And he says, it's something you get from the police departments where you identify yourself as a person working with the street homeless, sort of like a community patrolman. And it explains the reason why you're there or not there. That would have been the way to have prevented this. I probably could teach a course, so to speak, on how to operate as a retiree if you're trying to volunteer working with street homeless. I think I paid a visit to the homeless once a week in Miami-Dade and Broward. The mistakes were endless, and the lack of boundaries were endless. I tried to identify myself to the police in Broward. Broward's a very different county than Miami-Dade in terms of they don't like people working with the homeless, and they feel that the homeless should go somewhere else. In fact, they bought a homeless recovery center and transported it to a different county. Being that as it may, I've learned a lot from this mistake. I mean, for a PhD psychologist to be thrown into jail, the jails in Broward was like a prison. It was unbelievably scary and abundantly correcting. There's a lot of self-correcting I've done since then, and obviously reflection. I've actually been under treatment for the decisions and then trying to get back into my career as a psychologist. The actual DAG that was initially assigned to my case, David Corrick, did a 2-year review as to my case and came up with the notion to the board and recommending approval based on the fact that this exchange was innocent despite what appears to be quite the opposite. And when the board president at that time, Robert Kahane, saw the use of Lorset, he said that the woman could have died had she ingested that pill and that gone into anaphylactic shock, and that my license should either be suspended or revoked. Well, a new DA came about over years later, all along saying they did not agree with that decision by the board, and went ahead and took no action. So essentially went from 2007 to 2014 without any action. And then a new supervisor in DAG world came in, and they went ahead and said, you've got to resolve these cases. See if you can resolve these cases. So I got a call from the district attorney, Mara Faust, who said that, listen, you're no longer allowing no continuing education for out-of-state residents, psychologists. You can go ahead and surrender your license, and when you want to get it back, go ahead and we petition for reinstatement of your license, which brings me here. Obviously, I've learned my lesson from those events, and obviously things have changed substantially. You've got to remember that South Florida was a lightning rod for the pill world and made national reputation. There's no way that the county was going to drop that charge. However, I've tried to get back to work, but the problem of having a criminal record and no license really was substantial. However, the Broward courts allowed me to have my records sealed based on a review of the case, and the district attorney of Broward, this is last month, sealed my record, and they brought the case to the judge of Broward, and he agreed to the sealing of my case. I've included the details of the decision by the courts there, and this is through a company called Erase the Case. They went ahead and sealed my record. So that's the last step into going back to work, except for getting my license reinstated. The place to get a license reinstated, even though I'm applying in California, is the VA, where they allow someone with a state license. Out of state, doesn't matter what state you're in, and they could put you to work there. So, in essence, having a license in California would work there. Over the last several years, I've tried to get back to working at Napa State Hospital, where I was employed for a long time, and they simply did not have any openings. The only requirement for employment there was to essentially have an ability to to have a license. So I could have been hired had they had an opening there. Those are my two career choices. The skills that I bring back to the marketplace include pain management, obviously substance abuse, as I've been in recovery since '86, and I went through quite a long period of recovery from alcohol and a 2-year period of drinking. I heard the last case, by the way, and I wound up getting sober since '86. I've never had a drink since, and I certainly don't abuse medication. I respect all those. And where we are right now is I need to go back to work. I'm 75 years old. I have a lot of skills. I'm a former president of Marin County Psych Association. And before I left Marin County, I was asked to run again as president of Marin County Psychological Association. I have a history of serving the public. I was the chairperson of the Disaster Preparedness Committee in San Francisco. And so working with the disenfranchised homeless was something that I was used to, and working on the streets I was used to. I was also a former community mental health psychologist for the city and county of San Francisco, and worked to populations on the streets of San Francisco during my employment there. I won't go on anymore. I'd rather hear from what the considerations or the reservations of the board are and answer those questions. Sorry I won't go on so long, but I thought I'd have to answer some of these issues and questions so people would understand who I am and what my intentions are and what they were. I guess that sort of leaves it up to you guys to deal with whatever reservations you have about me being reinstated. I will end with the psychiatrist who I've been seeing the last 2 years in treatment, who said he made a foolish mistake in judgment and errors 15 years ago. It scared him, and he never did it again. And I don't think there should be any limitations on his license at this time. I also have an enormous number of psychologist supports here who I talk to about the issues we've just been talking about. So with that, I'll turn it over to the board and you, Mr. Lent, as to where we go from here. I'm unfamiliar with the rest of the process.
All right. Thank you, Mr. Sabatasso. I am reminded as I look at the clock that we have about an hour and 20 minutes until the 5 o'clock hour. And I'm going to, at this point, which I hate doing in any case, but I'm going to impose some limitations on the time so that the board can use its time best. I do this because I know that there is a substantial record in this case. Mr. Len indicated that there were clearly, nearly 300 pages, I believe. So, Mr. Lent, I'm going to ask you please to be efficient and focused in your cross-examination, knowing that you can make many of the same points from the record that is already before the board. I would encourage you to try to wrap it up within 20-25 minutes so that board members can have an equal amount of time to ask their questions and go from there. So Thank you for assisting and cooperating in this respect, but I am confident that in this case there is a substantial record from which to draw, and that cross-examination may not be as critical. Thank you, Mr. Lent. You may proceed.
Thank you, Your Honor. I shall endeavor to do my best to be concise in my questioning and cross-examination. Dr. Sabataso, before we go into your petition in this matter, I just wanted to clarify a couple things that you had brought up in your narrative just now in your testimony, and I just wanted to clarify a couple background questions, if I may. Is it correct that you moved to the state of Florida in or about the year 2007?
No, I moved here in 2003. It was 2003 that I moved from California. I came back, but I moved here and relocated.
Thank you, sir. And I apologize, given the limitations on my time, I would appreciate if you could only answer the question that's being asked upon you. If you want to elaborate, please do so at a later time. But given the time specifications, I want to be as concise as I can, as the judge has informed me I can be. Okay, sir?
Absolutely, yes.
I appreciate your cooperation in that. Thank you.
Sure.
So according to the documents that have been received in this matter, you submitted an application in or about 2005 to the state of Florida to apply for a psychology license. Is that correct?
Correct.
And is it also correct that you have never been licensed in the state of Florida to practice psychology, even up to today? Is that accurate?
Very accurate.
And you've been residing in Florida for over 15 years. Is that correct?
That's correct.
You had indicated in your direct statement just earlier that you have been sober since 1986. And in your interview with Special Investigator Nicole Walker, you admitted that in 1978 and 1986, you were convicted of 2 DUIs and that you consider your sobriety date 1986. Is that also accurate?
Correct.
Did you ever report those DUI convictions to the board?
Gee, I had no idea one had to do that. No, I never thought of it.
Okay. And you stated that you've been sober since 1986. How do you define your sobriety, sir?
Well, I don't drink, and I certainly don't abuse my medication. Anything that, to me, that changes or alters your mood, to me, is a break in sobriety, such as abuse of any medication that changes your mood. As simple as that.
My understanding from the record and the evidence is that when you were arrested in 2007, you were in possession of a Schedule II controlled substance, several Schedule IV controlled substances, and based on your interview with Investigator Walker, you are currently taking OxyContin twice a day and oxycodone when needed. Is that correct?
That's very accurate.
Okay. And is it correct that those are also Schedule II controlled substances?
Absolutely.
Okay. Do you see any conflict with your stated sobriety date and your continued use of these types of controlled substances?
Absolutely not. They're medications. They're not they're not drugs to be abused. I respect the medications, but I've been a chronic spine pain patient for 3 decades, and I've evolved from using from the '78 when I was hit by the truck. When they were prescribing ibuprofen and Soma for treatment of back pain, moving from that to using tramadol and hydrocodone throughout the year.
Thank you.
Then evolved to the new medications.
Thank you, sir. I appreciate that. I want to direct your attention now to your petition for reinstatement of your surrendered license. This is starting in Exhibit C for the board, your honor, and petitioner's edification.
Okay.
So in that petition, I'm going to look under employment history, AGO page 29. You left that blank. You left the whole form blank, but you did attach some narratives to that. You attached your resume, and you also attached some explanations. The resume that you attached, I looked at. You have two resumes that you attached. One is Exhibit C, AGO pages 32 to 33, and Exhibit F, AGO 154. Looking at those, I have two questions. My first question is, when was the last time you were employed?
Well, that's a good question. I was employed when I was in California. I retired at age 55, so I hadn't been employed since then. Like I've been, as I said, I've done service and I've applied for positions, but given my record since I was only in Florida for 3 years before the arrest.
So is it fair to, I apologize for cutting you off, sir, but I want to get to the point as quickly as I can. Is it fair to say that the last time you were employed was in or about 2006?
No, I wasn't employed in Florida. Where did you get that from?
Well, I'm looking at your two resumes, the ones I just indicated, Exhibit C, pages 32 to 33, and Exhibit F, page 154. And the resumes, curriculum vitalis, do not seem to mesh very well as far as the dates are concerned. And so I wanted clarification from you as to when the specific last year that you were employed is.
Well, I was self-employed throughout till 2001 when I left California, and I closed my practice there. I'm self-employed. I haven't been employed by any agencies here. Basically, through my volunteerism for those 3 years before my arrest.
And when was the last time you volunteered, sir?
Well, I mean, in 2007 when I was working with the street people, but I mean, there's no such thing as a retired psychologist. I mean, I help people in terms of supporting people in my community here. I mean, it goes with part of who I am.
Well, when you mean a psychologist never really retires, and you've referred to yourself as a street psychologist, and that you counsel street persons, what is it you are doing as an unlicensed psychologist in that capacity?
Well, that's an excellent question. That's the whole mystery. How do you get somebody off the street and into recovery? I mean, I looked at the background of Mr. Fu, where he said his goal is to end homelessness in Los Angeles. In essence, my concept was to see what possible ways or means there was to get somebody off the streets into recovery and into shelter. But persuading them into a less riskier lifestyle or environment. And taking people to Salvation Army and homeless shelters and churches and so forth. There were a number of places that the homeless were sheltered and put to work. There's a letter in my package there, one from one of the fellows that I worked with, that everybody knew me on the streets as Dr. Tony, the guy that helps people. The other one was from a mother who, the daughter, I drove around to try to get her into
Dr. Santoso, once again, I apologize for interrupting, but I believe you've answered my question, so I want to thank you for that.
Thank you.
Thank you. Right now, I want to go to Exhibit F, page 57 through 65. That's your disciplinary action sheet attachment B. That's when you filed supplemental to the actual petition in this matter to the investigators. And so directing your attention there, the first question on AGO page 57 for your disciplinary action sheet asks you, does the decision require you to admit all or some of the charges in the accusation filed against you? Yes or no? And you left that blank and you didn't check either yes or no. Why did you do that, sir?
Well, it's a wide variety of charges there, I suppose. And it goes without saying, one, to admit wholesale things that are not true or mischaracterization seems like an error in judgment to me.
Okay, so I want to clarify something because you did make mention of this in your direct testimony in your narrative earlier today. is you began by saying that you contest the contextualization of the events and that they were distorted. And you spent quite a bit of time talking about a different narrative of the events that transpired back in 2007 earlier today. When you executed your accusation and stipulation to surrender, you admitted and agreed to the factual basis as articulated in the accusation, did you not, sir?
Yes, yes, I did. In essence, the charge that was held against me was delivery of hydrocodone 1 pill to this person. And that's the essence of what I did. And when I admitted to the accusations by the board chairman of confusing the police whether I was licensed in Florida or California, it didn't seem to be a relevant concern, but that's not up to me to decide. That's what I essentially was admitting to, was that I delivered the pill, offered the woman a pill who was in pain, and that's the essence of why I agreed to that. Plus, I was cooperating with the DAG at Mara Faust, who wanted me to work with her to surrender my license and then reapply here and now. So,
and
yeah.
so, okay. And Dr. Sabatosa, you gave a very detailed narrative today in your direct testimony in regards to what occurred that day. You described the woman coming into your car with a yellow
Correct.
paper in her hand, trying to get her food, not giving her a cell phone. You described in great detail all of that. You even described how the officers informed you that it was a humanitarian gesture. Is that your rendition of the events?
That's the reality, Mr. Lentz. Yes, that is the rendition. That's the accurate what took place.
Okay. Looking at the police report in Exhibit D, specifically AGO page 177, most of your narrative that you told us today is not included in any of the reports or your statements to the police officers, nor is it reflected in the factual basis of the accusation that you stipulated to. Can you explain that discrepancy?
Yeah, completely. One, the officer that told me to drive her home would have made a perfect witness, but I never was able to identify who he was. That's one. Two, the officer, Kathy Wild, who said, I'm going to write this up as a humanitarian gesture and you'll be protected by the Good Samaritan Act, I think is in a police report somewhere. And
Actually,
yeah.
Actually, if I may interrupt, Dr. Sabatoso, on Exhibit D, AGO page 177, the first paragraph, the report indicates that you told the police officers that your action was a humanitarian gesture, and that's how it's quoted in the report.
Right, I suppose so. I mean, the point of the matter is it was not my attempt to give somebody I was taking to a hospital a controlled substance. The intention was completely the opposite of everything that I was doing. And so I thought it was going to be treated fairly, and just the opposite took place. I mean, there's no other way to put it. And so I agreed to admit that I gave her the pill, and I was charged, and that was what I was pled no contest to, and that's why I served the 18 months of probation, which essentially was saying, yes, I delivered the pill to the woman. She never consumed the pill, by the way. She threw it on the street, and that's the long and the short of that story. And that happened 15 years ago. I don't have a history of any of that or subsequent to that or prior to that. And my devotion is to getting people off the street and into recovery at that time. But as you know, I just said, I've since been doing other things in terms of helping the public and so forth.
Dr. Sabatoso, in your attachments that you included within your petition, you described this woman in different aspects in different locations of your petition. In one particular location, you describe her, quote, as a stranger whom you had just met. In another instance, you describe her as a disabled woman. And in another instance, you describe the fact that you were aware that she had prior criminal conduct and you were familiar with her. And in her statements to the police officers, she informed the officers that you were a regular prostitution client of hers. Can you explain these discrepancies as to how you're classifying your interactions and your knowledge of this woman?
Well, all four of those descriptions are what would be obvious to anybody. She was crippled and disabled, and she was who she was. I mean, she was a street prostitute. And by association, anybody can draw what they like and invent things around that, such as giving her drugs for the purpose of paying for services, which was pretty bizarre. And the rest of those characterizations of this woman I've seen on and off on the street, but I've never attempted to think that I could help her. And that's the essence of why I characterized her as disabled. She was physically not able to walk well because of two failed hip operations. So I was
Dr.
familiar.
Sabatoso, thank you. In your interview with Investigator Walker, it's Exhibit E, AGO pages 193 to 242. At one point, you told her that you believe the standard of care of a doctor-patient relationship was not appropriate to apply to your case because the woman was not a patient of yours and that this was a personal behavior and personal exchange between the two of you. Is that accurate?
Absolutely.
Okay. So is it your understanding and belief that what a licensed psychologist does on his or her own personal time has no impact on their license?
No, anything but that. Carrying a license and holding yourself out as a psychologist, one has to be explained to other people that you're responsible for what you do, and it has implications. People, as the newspaper said, the accurate newspaper stated, says, psychologist gives pill to prostitute, cops say. And then in that article, I went into details about how funny it was that the guy who holds himself out as an expert and is an expert witness defending drug addicts and street prostitutes and so forth listed my email, and they said that essentially he's going to have to explain himself to the law and to a judge. So he thinks that he was not going to have to explain himself.
Well, Dr. Sabatoso, isn't it true that when you were arrested, you told the police officers that you were counseling this woman, and that's reflected in the police reports?
Well, that's what I mean by context. Context is everything, and this is the whole key to this entire discussion.
Well, isn't it also true that I apologize.
The question was implied when the officer approached the car, are you dealing drugs here? What's going on here? And so my answer was, no, I'm counseling her. Basically, I'm helping her to get to the hospital. That failed, so that did not work out. So I was letting her off at the very public place where she could not consume any more drugs. That was the essence. That's the whole concept of counseling was used in the colloquial use of the word counseling, certainly not in a psychotherapeutic context where there's a doctor-patient or in the front seat of a car.
Well, Dr. Sabatoso, did you also not identify yourself as a psychologist to the police officers?
Of course I did.
Okay. And do you think that it is a reasonable inference for a police officer to assume that when someone identifies themselves as a psychologist and claims that they are counseling someone, to infer a proper course of conduct?
Certainly. The concept being, are you counseling her, was meant in a colloquial way. They didn't want to accept that. That had nothing to, they were not interested in my professional or non-professional or personal behavior there. They were interested in the law, breaking of the law. It was the board that took on the concept that I was engaged in a counseling relationship with her, a clinical relationship with her, which is entirely a mischaracterization of what was taking place.
Dr. Sabatoso, in your disciplinary action information sheet, question 6 asked, how would you handle the situation which led to your discipline were to happen again today? And you left it blank, but you did attach a narrative, so to speak, within those same exhibits. I believe it's page 64 of Exhibit F, page 64. And in that page, as well as during your narrative direct testimony earlier today, you say that you needed a badge, and if you had a badge, that would have avoided the entire arrest process. And you kind of repeat that same line of thought throughout your petition, is that if you had a badge or some type of authorization, it would have avoided this entire circumstance. Is that accurate?
The misunderstanding would not have taken place at any level, because the badge would say you're doing something that's being looked at and controlled by somebody else, such as the judge informed me that he had a badge, and that had I applied for a badge, which I was totally unaware of, that they would understand my reason for being there. As several of the police officers said there, we know you're not a street person. We know you're not a drug dealer. We see you're a psychologist, and that was the end of it. That was their interest. Their interest was simply, why do you have these medications? Do you have prescriptions for them? And did you do something illegal by giving her the pill? And yes, I pled no contest to giving her the pill, and all the other charges were dropped. I served the 18 months felony probation. And since then, my felony arrests have been sealed, and I hope to get back to work as a psychologist and contribute to society. It's been 15 years.
Well, Dr. Sabatoso, when you answered that question on page 64, you talked about having an identifier and a badge. You talked about refraining from carrying loose prescription drugs, but at no point did you address refraining from giving a civilian a controlled substance, such as hydrocodone. Why is it that you did not address that specific conduct in your answer to question 6?
Well, everywhere else, the details of the police report and arrest report and the felony record is all documented. I mean, to state the obvious, I already pled no contest to delivery of the medication. I mean, simple as that. To restate that was no problem for me, because that's been indicated everywhere else, or I wouldn't have had to serve the probation. I wouldn't have accepted the reality of it. That was it. And the reality of it, this took place 15 years ago. The woman didn't die from the pill. She never ingested it. There was no intentions to give her drugs, as the former chairman of the Florida board testified to. Dr. Sabatoso works with people who are injured and people who are disadvantaged, and he's spent his entire career working with people who are ill, people who are drug addicts, people who are substance abusers, people who are dual diagnosed, and so forth. And this is
Dr. Sabatoso, I don't mean to cut you off, but I would like to ask you a few more questions. So thank you for addressing that. Moving on to question 7. It asks what assurances you can provide the board that you will not reoffend. And on AGO page 65, you included an attachment. In that attachment, again, you referred to obtaining a legal badge of authority from law enforcement, and you stated that you've learned and have a deep respect for the care of your medications. But again, you don't reference any point in time providing a civilian who you did not conduct a history of or wasn't a patient a Schedule II controlled substance. Why is it you did not include that in your answer to question 7, sir?
Not quite sure I'm following you. I think I've covered everything that was asked of me. I tried to be as comprehensive to that question as possible.
In that response to the question, you also described the period during which your California license was surrendered as "quote unquote" a period of infraction. Do you view your conduct as an infraction?
Hardly. It's a felony offense, even though it's a third-degree felony. I've never been arrested before. It's hardly an infraction.
Okay, then why did you describe? Doctor, I apologize. Why then did you describe it in your answer as a period of infraction?
Well, that's a misuse of the word. I'm sorry that that's being amplified here. It was hardly an infraction.
Okay. I just wanted to make clear what your intentions were. Thank you, sir.
No, there's no attempt to diminish the traumatic event that took place. That's changed my life, my career, my reputation, my savings, my income, and my future. That's why I'm struggling here to get my license back. It's hardly an infraction. It's a devastating. It's the 9/11 of my life.
Turning to your evidence of rehabilitation sheet, which is Exhibit C, or rather Attachment C. It's contained in Exhibit F, AGO, page 66. Again, you left questions 1 through 6 completely blank, but you did include attachments in addressing them.
Right. I attempted, excuse me for a second, I attempted to use the narratives as a way of describing what took place, because that way would be best understood by others. And that's why I use the narratives in terms of leaving it blank. I don't remember that part, but in the narrative, I explained everything that happened and everything I did and took full responsibility and accountability to it.
Okay. There's no question pending. Doctor, there's no question pending at this time, okay? Thank you. I want to ask you in regards to question number 1 on your evidence of rehabilitation sheet. It asks you to provide coursework in the area pertaining to your offense. And I looked through all of the documents that you supplied, and correct me if I'm wrong, you supplied 9 certificates of completion of continuing education between December 22nd and 23rd of 2019. Is that correct?
Yeah, an incomplete number of certificates. Actually, I did 37 hours of continuing education because 36 were required. But if you look at the summary sheet, it says 37 hours of continuing education. Those occurred 2 years ago, Mr. Lind, and now they've expired, so I have to repeat them as of December 25th of last year. So I'm due for another 36 hours, and now I understand it has to be 3 hours face-to-face and live continuing education.
Dr. Sabataso, in reviewing Exhibit C, AGO pages 41 to 48, I could only locate 9 certificates of completion in the areas of spousal abuse, suicide assessment, sleep disorders, ethics and boundaries, human sexuality, aging and long-term care, and therapeutic communities. Besides the ethics boundaries course, could you please explain how other courses pertain to your offense?
Other courses on boundaries, obviously boundaries is the biggest one. Ethics is certainly salient. That clarification. I think I included comments on communication and improving communications with others. That's certainly part of it. But I think those are the best courses to have addressed the events surrounding this arrest that I could pick.
Understood. In the balance of that evidence of rehabilitation sheet, you talk about how you've sought out therapy and counseling, and you reference Dr. Strauss in question number 3 in regards to ongoing psychological evaluations within the last 6 months. Okay, is that accurate?
Yes, I've seen Dr. Strauss for 2 years, and co-occurring with that, I've obtained psychological counseling from another psychologist, which I didn't include in this picture, but could have. And now I'm obtaining psychological counseling right now from another psychologist. It's started since my petition was filed. So I've got
Dr. Sabatoso, just to clarify, the only psychological report and or letter contained within your documentation is the letter from Dr. Strauss from March of 2018? Or sorry, March of 2020. I apologize.
Yeah, that's the letter that substantiated my psychological counseling and and review of my behavior, current, past, and what's going to be hopefully my future.
And Dr. Stroud states in that letter that he has not read a copy of the decision and order in this case. Rather, he states that all the information he's received about this matter has been given to you. Why is it you chose not to provide your psychiatrist with a copy of the decision and order in this case?
Hardly. Dr. Strauss has a full copy of, and had the full copy of the every single detail that took place in a packet that I provided him. But since I'm a Medicare client, they don't cover forensic reviews, and he could only review it personally. He knew all the details of my arrest and my circumstances, and when Nicole Walker called him, he requested a $1,400 advance, which she didn't want to pay and nobody wanted to pay, and so that's why he came up with this description of what took place.
So, Dr. Sabatasso, if I can direct your attention as well as the board's attention to Exhibit F, AGO page 71. That's the March 2020 letter by Dr. Strauss. The third paragraph from the bottom of the page starts, quote, "I have not read a copy of the decision. All the information was given to me by Dr. Sabatasso."
Yes, he has not read. He did not read the decision that I gave him. All of the decision I gave him in a full 7-item packet that actually he gave me back the last visit I had with him 2 weeks ago. I was quite angry that he never read it. I was surprised he didn't read it, quite frankly. And he retaliated by saying, "Did you expect me to read all this without getting paid for it?" I said, "Well, I was unclear that you were not going to read it, and I was unclear that you wanted to be paid for reading all of this." But there was no attempt on my part to keep anything from my psychotherapist or Dr. Strauss, period. I mean, everything was self-disclosed. The details of it discussed for 2 years.
Dr. Sabatasso, just so I'm clear, you're claiming that you have been under psychotherapy with Dr. Strauss for approximately 2 years now. And in that time, you're detailing this very serious offense that occurred that has affected your life. And you have discussed it with him, and he has chosen not to look at the decision or read anything further from it. Is that your representation today?
Yes, that's what I was so angry about.
Okay.
My representation is the truth, Mr. Led. There's no other different way around it. I gave him the details of the report and the arrest, and he chose not to read it. And that infuriated me. I did a lot of effort to courier it over to him, and he just handed me back the packet.
Okay. Question number 5 in that same packet asks what you've done to stay current in the field of psychology. Besides the 9 certificates of completion that are contained within Exhibit C, pages AGO 41 through 48, from December 22nd to the 23rd of 2019, were there any other certificates of completion or evidence of coursework or anything else that you can establish that you've stayed current in the field of psychology?
Well, as a psychologist, you stay up on all psychology by reading different textbooks. I'm reading 3 right now, one on high conflict, one on 2 different books I'm reading at this point. I mean, that's the only formal indication of continuing education. But I'm a lifetime psychologist. I was a psychologist since I was a child. I mean, I basically became president of the National Honor Society for Psychologists at the University of Miami because I was the one that was motivated to promote psychology. And since then, been studying psychology. And
well,
so
Dr. Sabatasso,
taking continuing education. I mean, you as a lawyer would know that. You don't just take continuing education and deal with it as the only source of interest or reading.
So, Dr. Sabatasso, I can see that the 20-minute mark that Administrative Law Judge Liu has given me is almost winding down. I just have a couple more questions to ask you, and I'm trying to condense my cross-examination extensively into a limited period of time. So I'm just going to ask you a couple more questions, sir. Your license was surrendered in 2014. It is 2022 right now. Why are you applying to have your California license reinstated at this point in time?
Essentially, I need to go back to paid work, and there are job opportunities, all of which that I'm on Indeed and other job sources, all of which require you be licensed, including positions in California. My license needs to be reinstated to go back to work.
And so, in that same
run out of money.
Okay. In that same justification, why not simply get a psychology license with the state of Florida, where you've been residing for the past 15 years?
Well, yes, that's the next step. The first step is getting a California license and going back to work locally, because that's the easiest first step. The second step is showing that I've got my California license reinstated and use that as a leverage point for the Florida state relicensing. The only thing that was missing in my Florida application was the passing of the laws and ethics, which I've missed twice. So that's the veneer of California will impact the Florida licensure, so I can get licensed here.
So I just heard it, and I want to clarify that I heard you right just now. You took the law and ethics course for the Florida State Psychology Board, and you did not pass it twice. Is that accurate?
That's accurate. I missed the questions on child boarding requirements. So you go to the national board, you go to the school, and so forth and so on. So yes, I had to take a review course to take the exam, and by that time I was arrested. So my application for Florida was truncated. I have to go back to do that.
As part of your stipulated surrender and disciplinary order in this case, you agreed that in the event that the board ever reinstates your license, you would pay the $7,000 owed to the board for the costs of investigation and enforcement. During your interview with Nicole Walker in this matter, you told her that you do not have that money to repay the board. Is that accurate?
What I stated to her was that I understand from other psychologists who've been reinstated that they pay the board back in payments. As soon as I get back to work, that I'd make the arrangements to pay the board back in payments that when I had income coming in from my work. That's what I stated.
Your Honor, I know that I've only been given 20 minutes for cross-examination. I've tried to hit as many of the salient points as I can. I do have several other questions to ask the petitioner, but I do see that my time has essentially expired. So I will yield to the board for cross-examination and inquiry of the petitioner, but I wanted to make the representation on the record that my cross-examination was not as extensive as I would have had if I had been given more time.
That's well understood, and I appreciate, as does the board, very much the efficiency with which you engaged in cross-examination. This has nothing to do with you and everything to do with the time limitations that we have, and my wanting the 9 members also to have an opportunity to ask questions. I'm hopeful that during the course of your closing statement, you can highlight anything else from the record that you may have wished to have gone through in cross-examination. I'll now turn to Board President Dr. Tate. If you have any questions, please pose them at this time.
I just have one question. In the deposition, with one of our board staff, you mentioned that you were in assisted living. Is that an accurate statement?
No, I don't know. Now, the context was I need to go back to work. God forbid I'd have to get so broke that I'd have to go into assisted living. Was my humorous comment. No, I was not. I was in here, retirement community here in Boca Raton with my girlfriend. Fortunately, she provides shelter for me.
Okay. Thank you for answering, sir. No further questions. Thank you for being here with us today.
You're welcome.
And Vice President Fu
Thank you, Your Honor. No further questions for me.
and Dr. Kasuga.
Thank you, Your Honor. I also don't have any questions, and I appreciate the petitioner's time. I mean, petitioner's time.
Dr. Cervantes.
Thank you, Your Honor. Dr. Sabatasso, thank you so much for being with us. I only have one question. Could you tell me how you understand boundaries between a psychologist and a patient?
Well, if you're a psychologist, it's all about the therapeutic relationship. Either you have a therapeutic relationship that's defined and specific and understood. I think an example might be that I was called one point and I was asked to come down and help a woman who had been shot. And this was by a street person. So I arrived downtown and the woman was standing there with a bullet wound in her arm, and I called 911. The whole squad of 911 people showed up, and they said, "We want to put you in custody. This man here claims he's a doctor, and we have no reason to not believe him." And she put it very clearly. He may well be a doctor. He's not my doctor, and I don't want to go to the hospital or anywhere else. So in so many ways, psychologist is either in a therapeutic relationship with somebody or they're not. Passing somebody on the street or telling somebody you're a psychologist does not constitute a therapeutic relationship any more than Mr. Lent being my attorney. It's all about formal boundaries and structure. It's about the therapeutic relationship. That's where the context is. It's not about anything more than that. I don't know if I answered that question. It's best I could come up with.
Thank you. I have no other question.
Dr. Harpsheets.
Hi, I have just one question. Dr. Sabatasso, could you please share with us your understanding of practicing across state lines?
Right. There's no reciprocity for Florida, for the state of California, rather. And the only opportunity to practice across state lines would be conducting Zoom interviews with clients in California. That's the only place I'd be licensed to operate there. The other ones where, like I mentioned, the VA does not require you to be licensed in the state of Florida to work here. So my ultimate goal was to be licensed in both states, so I would not have a problem. I would be bi-coastal psychologist rather than anything else.
Okay, thank you very much. That's all I wanted to know. Thank you.
Sure.
Board Member Julie Nystrom.
Yes, Dr. Sabatasso, I don't have any questions. I just want to thank you for your time today and for answering the questions.
Thank you for listening to all this, and I appreciate all your time and understanding and compassion. I can see by the questions that have been designed for the petitioners. And I've watched the board over the decades that the board has evolved into a much more understanding group of people and perspective.
And
Well, thank you all.
Dr. Phillips.
Excuse me. Yeah, I do have some questions, just a few, and I'll try to keep them as brief as possible.
Sure.
Dr. Sabatasso, do you still hold yourself out to be a psychologist?
Well, I'm a psychologist, but not a licensed psychologist. Correct. I tell people I'm not a licensed psychologist. So when they come to me for help, I explain to them I'm not a licensed psychologist. I'm only a trained psychologist with a PhD, but no longer licensed. So that's the long and the short of it.
And do you practice psychology with them?
No, as we just discussed, it's about a therapeutic relationship. I could not engage in psychotherapy or psych testing without a license. Absolutely not.
In looking at your CE hours, your continuing education hours, there's a summary document at AGO 144, which would be 252 in the PDF, to the extent people want to refer to it, indicates that you have a total of 37 credit hours.
Thank you.
From CE for CE for less, or my CE for less, I guess is the provider.
Correct.
I'm a little curious. 31 of those 37 hours were issued on the same day. How do you get?
Right.
How do you get 31 CE hours on one day?
You work all day long, taking 2-hour courses, and you got it done.
There's
Christmas Eve, actually.
There's not 31 hours in the day, though, is there?
No, it was a date. Whatever date the test went in, it was the date that it was done. I didn't fill out the dates, but the dates were done. I did my CE hours over the weekend, Christmas holidays.
Okay. When you were seeing this young woman and you were ultimately arrested, were you or were you not operating as a psychologist?
Absolutely not. I wasn't operating as a psychologist. I was actually
that's sufficient. That's sufficient response. When you had a psychology license, did that allow you to dispense drugs?
Of course not. It's going to be anything worse than that. I mean, my APA training at Patton State Hospital in 68 and 69 were not allowed to even give a person an aspirin. So it was a horrendous error in judgment and behavior, Dr. Phillips. I have completely surrendered to the mistakes that were involved, which are endless and could go on all day about them.
Okay.
Certainly, you've heard some of it, of course.
You do provide us with a couple of copies of your current curriculum vitae and a copy of your business card. The curriculum vitae, curiously enough, shows you as a licensed psychologist.
Right.
With a license number.
Right. I was licensed up till the first resume was put together, and then after that, I added a supplemental resume. But I was licensed till, like it says, 2014, or whenever it says that I surrendered it.
Okay. So you had no license after you surrendered it, correct?
Of course not. That's where the license went. That's why I'm here.
But you continue to refer to that license number in documents. Well,
there was a period, yes, that I was licensed from 1977 till 2014 or 17, as far as I know. I have updated it by saying formerly licensed psychologist, PS 5211.
Was the business card you provided your current business card? It says clinical and consulting.
It was not. No, it was not. I would not. I don't know where that one came from, but it's an old card.
And you don't know how the examiner gave him possession of it?
I may have given it to her for the spelling of my name as an old card, but obviously I don't hold myself out as a licensed psychologist, or I wouldn't be here.
Okay. I don't think I have any further questions. Thank you.
Board Member Riscotti.
I don't have any further questions. Thank you.
Thank you. And finally, Dr. Rogers.
Thank you so much. Dr. Sabatasso, thank you for your time today. We appreciate you being here. Thank you.
Thank you for hearing me out. All
right. At this time, I'm going to invite closing comments. And so that Dr. Sabatasso has a chance to respond, I'm going to ask Mr. Lent if you would go first, please.
Yes, Your Honor. The practice of psychology in California affects public health, safety, and welfare, and is to be subject to regulation and control in the public interest to protect the public from unauthorized and unqualified practices of psychology from unprofessional conduct by persons licensed to practice. In addition, protection of the public shall be the highest priority for the Board of Psychology in exercising its licensing, regulatory, and disciplinary functions. Whether the public is inconsistent with other interests sought to be promoted, the protection of the public should be paramount. A person whose license has been surrendered may petition the board for reinstatement after 3 years from the effective date of decision and order. Since petitioner's license surrender became effective March 2nd, 2014, petitioner filed this petition February 4th, 2021. It is timely. Petitioner bears the burden of establishing his rehabilitation and present fitness to practice psychology such that reinstatement of his license is warranted. The standard that the petitioner must meet is that of clear and convincing evidence. The evidence presented by the petitioner must be considered in light of the moral shortcomings that previously resulted in discipline, and the showing must be sufficient to overcome the former adverse determination. In considering a petition for reinstatement, the board considers the following criteria in evaluating rehabilitation or present eligibility for licensure: the nature and severity of the acts, evidence of any acts committed subsequent to the act, the time that has elapsed, the extent to which the applicant has complied with terms of parole, probation, restitution, and evidence of rehabilitation. In reaching a decision on disciplinary action under the Administrative Adjudication Procedures of the Administrative Procedure Act, the board shall consider and apply disciplinary guidelines and uniform standards related to abusing substances licensing, which is incorporated into the board's regulations by reference. The disciplinary guidelines further define rehabilitation as the following. It is evaluated according to an internal subjective measure of attitude, a state of mind, and an external objective measure of conduct, the state of facts. The state of mind demonstrating rehabilitation is one that has a mature, measured appreciation of the gravity of the misconduct and remorse for the harm caused. Petitioner must take responsibility for the misconduct and show an appreciation for why it is wrong. Petitioner must show and demonstrate a course of conduct that convinces and assures the board that the public would be safe if petitioner is permitted to be licensed to practice. Petitioner must show a track record of reliable, responsible, and consistently appropriate conduct. Rehabilitation, again, is a state of mind and the law looks with favor upon rewarding the opportunity to serve one who has achieved reformation and regeneration. Fully acknowledging the wrongfulness of past actions is an essential step towards rehabilitation. In this case, petitioner pled no contest to the unlawful delivery of hydrocodone, an opiate analgesic combination product used to treat severe pain that is classified as a Schedule II controlled substance. This conduct is serious and severe. It could have caused serious and severe injury or even death to the woman that he gave the prescription medication to. In support of his petition for reinstatement, petitioner included only 3 emails and letters of support, which date from August 2007, October 2007, and April of 2009, all of which predate the filing of the accusation, which occurred in July of 2010. Petitioner's single letter from his psychiatrist, Dr. Strauss, dated March of 2020, states that even he has not read a copy of the decision and order in this matter. Rather, all the information he has obtained in this matter has come directly from the petitioner. The last time the petitioner was employed was in 2003, and the last time he volunteered in any capacity related to the field of psychology was over a decade ago. Petitioner has provided certificates of coursework for continuing education, which were completed within only a 2-day time period online from December 22nd to the 23rd in 2019, and only one of which of those courses deals with a topic relevant to his underlying misconduct, that of ethics and boundaries. With regard to additional evidence of his rehabilitation, petitioner contests the stated and stipulated factual basis of the accusation number 1F-2007-185372, as well as contesting the Hollywood Police Department arrest reports. Both in his interview with Investigator Walker and contained with the attachments to his petition, he states that the factual circumstances were distorted, exaggerated, and the context of his exchange with a female prostitute was incorrectly described. Petitioner instead gives alternatives and at times contradictory narratives of the 2007 events underlying his arrest, conviction, and subsequent discipline and license surrender. For example, petitioner claims in one instance of his petition that the female prostitute was a stranger whom he had just met. In another instance, he claims she was a street person involved in a variety of petty and felonious activities that he was trying to help. And yet in a third instance, he portrays her as a, quote, major threat, end quote, who he had met the week prior. None of these are reflected in either the police reports or the factual basis articulated within the accusation. Each conflicts with one another. In Petitioner's efforts to rewrite history and paint himself in a more positive light, he attempts to challenge the female prostitute's character and undermine the credibility of law enforcement officers by attacking their alleged motives, none of which is supported by the arrest reports or the articulated facts in the accusation that the petitioner has already stipulated and agreed to in his stipulated surrender and disciplinary order. Petitioner also attempts to relitigate the outcome of his administrative disciplinary case by continually referring and referencing to settlement negotiations and settlement talks that occurred prior to the stipulated surrender and disciplinary order. In the documents he has submitted with his petition, he makes reference several times to other deputy attorney generals and prior settlement efforts without any evidence to support these claims other than his own self-serving representations. When confronted with the facts of his misconduct and whether he acknowledges any wrongdoing, the petitioner makes general admissions but continues to avoid specifically discussing the act of giving the known female prostitute his hydrocodone medication without a prescription, without an examination, without a history. And instead of acknowledging his behavior and efforts he could take to prevent similar conduct from occurring again in the future, time and time again, petitioner postulates that if he had some type of badge of authority, no arrest would have transpired. Petitioner repeatedly characterizes his conduct with the female prostitute as a personal exchange and describes it as a personal behavior with someone who is not his patient. This attempt to distinguish a doctor-patient duty owed to a patient in which he would have given hydrocodone to, in contrast to the facts of this matter, where he gave hydrocodone to a civilian on the street who he had no such professional relationship with, is blatantly wrong, endangers the public, and demonstrates a fundamental lack of understanding, insight, and appreciation as to the consequences of his misconduct. Given these circumstances and the totality of the evidence, it does not establish sufficient rehabilitation such that reinstatement is appropriate. Petitioner has failed to demonstrate that he is capable of practicing as a psychologist with due regard to public protection, and as such, the Attorney General's office recommends that the board deny his petition. Thank you.
Thank you, Mr. Lent. Dr. Sabatasso, you may address the board.
Yes, sorry that the characterizations of what I'm trying to do is being characterized that way. With regards to prior district attorneys reviewing my case, David Corrick, his file is with the board and with Mr. Lent and accessible to it. I didn't provide a copy of that, but I know that the Mr. Lent can obtain a copy of that, and you're welcome to review it. As far as more recent letters of recommendation, I certainly could bring more letters of recommendation, but I thought that the letters that I provided would be sufficient. Just to read something from the former chairman of the Florida board, Dr. Weitz. Although these letters were written right after my arrest, I never thought it would go this far or would result 15 years later in retroactive punishment. And I'll just say something that Dr. White said. Dr. Sabatasso never was a traditional office psychologist or the university practitioner. He worked with street people, the homeless, the disadvantaged, and the underserved. While his methods and operational style were unconventional, he always worked to better the lives of those in need. His concerns for humanity expressed his desire, not for money or fame, but for his doctoral degree to apply to the helping of those most in need. He signed as his former president of the FPA and former chairman of the Florida Psychological Association, who, by the way, I was sending a client to for them because he was running the Broward Addiction Recovery Center at the time. I discovered he was working there as a psychologist. As far as self-regulation is what I'm all about. I don't see myself as a threat to the public. I don't see myself as not understanding the laws, the ethics, the behaviors. I've I'm here because I spent many, many decades as a psychologist and many, 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 many hundreds, if not thousands of hours being supervised by some of the top supervisors over the decades of my career. I've worked at Patton State Hospital under supervision. I've worked at the County of San Francisco under supervision in the 70s, and Napa State Hospital under supervision, and passing all of those and never losing a job under those circumstances. This is talking about Napa State Hospital. I retired after 35 years of working in the Bay Area, which was difficult, and eventually got burnt out trying to collect money from lawyers regarding cases. I distinguished myself as trying to help others. I only come from the heart, and not from some sort of attempt to I guess, distort what my intentions were. There's no question that the acts that I committed on July the 11th, 2007, and the preparation to work on the street was insufficient. Had I taken it more seriously and set boundaries a lot clearer, this never would have happened. But as the reality happens is that when something goes bad, it really can go bad. And everything is fine until it's not. And this was the lightning rod of everything at once taking place. The city was under scrutiny for drugs and pill mills and doctors, and I had the quintella of all the wrong things happening at once. And I thought for sure that one, understanding and reason would prevail, which is a naivety on my part. I think my biggest crime at the time, and perhaps even today, sitting here realizing that there's still a prosecution of all my errors that took place 15 years ago, 2007, are still alive and well when you read them in today's world. I'm sure that I've written reports that sound like I'm evaluating somebody harshly, and I've reflected on how that's changed my behavior. I have a lot to contribute to psychology and the world, and I think that my value system is congruent with what other psychologists have. And I've got enough people around me who are aware as psychologists, both in substance abuse and in clinical settings, that have guided me in this last stage of my life at age 75. And I hope myself would be a cautionary tale in terms of making mistakes, but also a lesson for other psychologists and people who, at the end of their life, decide to do something involving the homeless, which is, as you know, has become a priority of the country. And with that, I leave you as myself, and whatever happens, I trust the judgment and the hearts of yourself, Dr. Sheets, Dr. Phillips, and I appreciate the time to explain myself. Thank you all.
Okay, thank you, Dr. Sabatasso, for appearing today. The board will give careful consideration to your petition and comments today. Mr. Lent, thank you very much for your representation of the Department of Justice. Your observations and comments as well will be considered by the board. The case is submitted. The record is closed. We are now off the record.
Thank you, Your Honor.
One bit of quick housekeeping. Mr. Reporter, Mr. McAleer, can you provide me, please, page estimates for the 3 matters? And if it's not something you could readily do, if you would provide it to board staff, they can get it to my attention.
Right, I don't have that at this time, but I can get that to you as soon as possible.
Right, find someone, please, that you can email to the board, and they'll provide it to me.
Okay.
I return it now to you, Board President Tate, in terms of what's your pleasure.
Thank you. The board will meet in closed session pursuant to Government Code Section 1126C3 to discuss disciplinary matters, including the above petition, proposed decisions, stipulations, petitions for reconsideration, and remands. Before we go into the closed session, I would like to let the public know that the board meeting tomorrow will be called to order at 9 a.m. If the board does not conclude closed session business today, Closed session will resume immediately after roll call tomorrow morning. However, if closed session business is finished today, we will call the meeting to order at 9 and then go directly into public comment and then the Department of Consumer Affairs update. After closed session is concluded later this afternoon, the board will go back into open session to recess the meeting for today. So we are going into closed session. Let's take a 5-minute break and regroup at 4:50. Thank you.